dream, but my dreams keep flying away. As somewhere far beyond, keep chasing them and I never rest for a day. There's something I don't do. I feel the wind blowing my face, but that's alright. I smile at people passing by. Some smile back, some might not. I'm always looking for a shade when it's hot. I've been low-key and I'm trying to stop. God, I'm feeling good. Yeah, but when off I go. Pretty afternoon, it's a fast forward. Looking at the skyline, looking back at my life, and I gotta say it's one of a kind. Yeah, but when off I go. Pretty afternoon, it's a fast forward. Looking at the skyline, looking back at my life, and I gotta say it's one of a kind. It's been a while since I ran into you on a street. I wonder if you moved. Hope everything is going amazing for you, and you're not feeling blue. I feel the rain pour down my face, but that's alright. I smile at people passing by. Some smile back, some might not. I'm always looking for a shade when it's hot. I've been low-key and I'm trying to stop. God, I'm feeling good. Yeah, but when off I go. Pretty afternoon, it's a fast forward. Looking at the skyline, looking back at my life, and I gotta say it's one of a kind. Yeah, but when off I go. Pretty afternoon, it's a fast forward. Looking at the skyline, looking back at my life, and I gotta say it's one of a kind. I slip to the right, bind it to the blue. I slip to the right, bind it to the I slip to the right, bind it to the blue. I slip to the right. God, I'm feeling good. Yeah, but when off I go. Pretty afternoon, it's a fast forward. Looking at the skyline, looking back at my life, and I gotta say it's one of a kind. Yeah, but when off I go. Pretty afternoon, it's a fast forward. Looking at the skyline, looking back at my life, and I gotta say it's one of a kind.
Oh, honey, bunny, sugar coming. White collar, white collar, white collar, white. Oh, honey, bunny, sugar coming. White collar, white collar, white collar, white. You're such a fool if you believe that you found the Jew, yeah. You're such a tool if you believe that you found the view, yeah. Your soul doesn't burn the fire. Your heart doesn't shock the wire. Oh, honey, bunny, sugar coming. White collar, white collar, white collar, white. Oh, honey, bunny, sugar coming. White collar, white collar, white collar, white. A white collar, she's probably asleep. A white collar, she doesn't wanna me. A white collar, she's probably asleep. A white collar, she doesn't wanna me. Oh, honey, bunny, sugar coming. White collar, white collar, white collar, white. Oh, honey, bunny, sugar coming. White collar, white collar, white collar, white.
Good afternoon, you sexy people. How are you? It's good to see you. And I forgot to turn on Nightbot, so Nightbot will not be stalking anyone. I turned it off for last night. and forgot to turn it on today. So, Nightbot is taking a vacation today. Nice to see you in the chat. So, today is Stephan Sterns' day to go in front of the judge to ask to suppress evidence. All right. So, I don't know if you guys have been keeping up with the Stephan Sterns case. And yeah, no stalking you today, CLK. So I don't know if you guys have been keeping up with that case. I have. There have been some things happening in the court system, and he's been asking for continuances. He's been asking for, suppression of evidence. Yesterday, he had a court hearing, and we can watch that real quick. It starts at 2 o'clock. I'm going to watch it through WKMG News. I have their notification on, so whenever it does start, we will be able to watch it as soon as it starts. But we will watch what happened yesterday and go from there. So let's pull that up. Maybe. I haven't pulled up here. Hang on a second. I don't know why my internet for the last couple of days have been freezing. And it's been doing stupid things. Now, let me put this on so I can share it. Share this tab, okay. All right, so put it on a little bit fast here.
We're on the record, State of Florida versus Stephen Michael Sterns, 2024 CF 632. Appearance for the record, please.
Danielle Pennell and William J. for the state.
Alicia Smith and Alex Johnson on behalf of Mrs. Stephan Sterns.
Thank you. All right, the court has set this hearing on the defense's motion to continue the suppression hearing, which is currently set for tomorrow afternoon at 2 p.m.
Very
Defense,
good.
do you wish to
Bottom
present
of the barrel.
argument with
Yes,
respect to
I
your
agree.
motion?
Yes, Judge, and defense has a case talk about it, topic of the state already. You want me to give you a moment to read, Judge, or you want me to?
Just a moment.
Hi, Wise Angel. Thank you for your message yesterday. I appreciate you.
These highlight the McKay factors.
Essentially, Judge, they all essentially stand for the same
I'm
thing.
familiar with the McKay factors. Thank you.
And the cases that I provided to the court are Botham v. State, 272 7th 3rd 876, a 50 CA case from 2019, Turner v. State, 311 7th 3rd 185, a second DCA case from 2020, McKay versus State, first DCA, 504 7th 2nd 1280 from 1986, and unpublished opinion that only has a Westlaw site so far, Surratt versus State, 2025, Westlaw 1119091 from last week, from April of 2025. Coca-Cola
Alright.
versus State, 867 7th 2nd 129, 50 CA from 2004, and Singer versus State, 286 7th 3rd 343, a 50 CA from 2019. Essentially, Judge, defense is moving to continue the motion to suppress the set for the afternoon, tomorrow afternoon. And looking at the Bofo case, it essentially says that in moving for a continuance, defense just has to show that we haven't had a reasonable time to investigate or litigate the case, and that is balanced against the judicial economy and judicial efficiency in the court managing their
But when the judge said a secret, whenever he says, listen for it, it's funny. I was like, this judge is funny.
documents turn into the McKay factors, as well as the factors that are listed in, I believe, Turner, that looks to a defense suffering an injustice by failing to grant the continuance, as well as if the delay was attributable to the defense or if it was unforeseen. Defense would argue that the intention is not to delay the court, isn't to be derelict in our duties. Defense is moving for this continuance based off of, as the court is aware, there is the second case, and preparing for.
I have to look that up. I don't know his name, but he's like, and he said delaying justice or delaying court is delaying justice. I like his way of thinking.
And preparing for the motion as well as in preparing the other case for trial, defense is coming to information that at this time the defense is in a position to be able to divulge to the court or in open court.
So your good cause is secret?
Essentially, Judge, well, I
What he
can't.
said, he said, so your good cause is secret? She's like, well, essentially. You can't do that, lady. I'm sorry. We're not starting off good, ma'am.
Faith at this time, being that it's still being explored. I don't know which way it's going to go, if it's going to be something that's going to pan out in favor of defense or be able to be something to be utilized in this case. As the court is aware, a death notice has been filed in the second case, and while I'm not arguing specific.
Surgery went well, and her little one is home. That's good to hear. I'm so glad. Now you get to baby him even more than normal, right? You got all the excuses in the world to love on him extra. And he can't tell you to stop. Thanks for coming in and letting us know. I appreciate that so much. So, yay, that's good. Kiss on him extra, and he can't say, stop.
As to that case, in that death notice, this case is used as one of the aggravating factors. So a conviction on this case would be one of the aggravating factors the state would potentially be seeking in the death notice in terms of a homicide case. Defense would argue that this information has come to light recently, and we're still in the process of working through it and figuring out if it's something that would or wouldn't be available in this case. If the defense were to go forward with the motion to suppress at this point, potentially would be relitigated depending on the court's ruling on that. In terms of just regular pretrial in the case, we would continue the regular pretrial even aside from the motion to suppress hearing, because we did an evidence viewing. We were able to complete the evidence viewing, and the second part of that evidence viewing is scheduled for June 11th with the state in this case. So defense essentially is moving to continue balancing both from factors as well as the McKay factors. Defense believes that this isn't a unreasonable request on the court in filing a motion and getting this set for a hearing, and still doing their due diligence in terms of preparing the case otherwise for trial and for the motion to suppress in and of itself.
Right. So the McKay factors, so we're on the same page, deal with a request to continue the trial. The other factors that you mentioned deal with a request to continue either a trial or a substantive hearing for absence of a critical witness. State response?
Yes, Your Honor. The state has not been in receipt of any witness list or any defense discovery.
Well, honestly, what the word on the street is, I don't know if you heard what the word on the street is, why he shaved. Allegedly, rumor has it, is that he's refusing to bathe. He's refusing to have hygiene taken care of, okay? So he had gotten bugs, bed bugs, skin bugs, okay? So they shaved his hair off of his body. Oh, do you think the judge gonna be like, well, I guess we're just gonna let you go because you're refusing to bathe. Hey, dum-dum, take a bath with your smelly ass. Should be a delay straight to court sentencing, then prison, over and done with in a day. Princess, I'm going to have to agree with you on that.
Discovery in this case. The defendant in this case was arrested on February 29th of 2024.
Yeah, I got you.
The public defender's office was appointed the next day at initial appearances. The discovery process started after the information.
Over here in this chat, we've learned to read through the lines. You know, we all mess up. Hey, KCG, good to see you, honey. We read through the lines. We're old over here. We can figure it out. Right? Hose his rear end down. Man, let me tell you what. Hose him down. Disgusting. I listened to his mom's interview on another channel. I'm sorry. And a mom of a boy, and nope, not babying him if he did that to a child. No freaking way. I have to agree with that. I listened to it too. I haven't been playing this stuff on here because there were so many channels that were doing it. So now that we're getting closer to trial, we can probably be prepared to do a refresher because we're going to go to trial. We're going to the trial. Now, I know that there are some TikTok people going to the trial. I'm going to be going, I think, from the 5th to probably the 8th or 9th. I'll be leaving the state for 2 weeks. So if it continues on, and then I'll go to the murmur trial. I thought I was going to be able to go to the entire one, but I can't. I have to go back to Illinois for personal reasons. But I will be going for a few days. Okay. Then if it's still going on 2 weeks when I get back, I don't know how long it's allotted for. Then I'll go back. But I have to be up there. So if I can come back, then. But I go back and forth from Illinois to Florida all summer long. But anyways, I will be there on the 5th. Now I know that they're going to have to go through a jury selection. I don't know if obviously that would be kind of not real good, wise financially to go there for the jury selection and stand outside the courtroom and all that stuff. But as soon as the first day is, if I'm still in this state, I'm going to go. And but I know that there's a lot of people. I don't know if I'm going to be able to get in the courtroom, guys. It may just be standing outside.
Was filed on March 11th of 2024. The state responded to the defense's demand for discovery on March 20th, 2024, and discovery has been ongoing. The motions to suppress that are currently set for hearing tomorrow were filed by the defense on February 6th of 2025. There was a motion to close the courtroom on February 28th of 2025. Notice of hearing for the closure of the courtroom was filed February 24th of 2025.
Yeah, that's why I go.
Upon the denial of the defense's.
That's kind of why I like smaller chats, because it gets it gets too fast, and I just like it. I don't know. In or out of court, you'll be the best person for me. Yeah, and I'm going to stream it even though I'm going to be out of state. I'm still going to stream it, okay? But I wanted to go there. I'm going to play this and put you on hold for a second.
Motion to close the courtroom on March 27th of 2025. The defense filed a notice of hearing for these motions to suppress. So these have been pending hearings since March 27th of 2025. The defense filed the motions to continue. The defense waited approximately almost 2 months, 2.5 months to request hearing time. The hearing has been set. The state filed responses to the defendant's motions to suppress on April 8th of 2025. And then I was contacted by defense. We had a discussion about their request to continue these hearings on April 10th, and a written motion to continue was filed on April 14th of 2025. The written motion filed by defense, the state's position is vague. It is unclear whether this information is necessary for a defense, is necessary for the hearing. The motion simply states that it may affect the presentation of evidence. The state has subpoenaed witnesses. We have a significant amount of hearing time scheduled for tomorrow afternoon. The state's prepared to proceed on the motions and is objecting to the motion to continue the suppression hearings.
Thank you. Any additional argument from the defense?
Yes, Judge. Defense would say that this is
Okay.
for the defense,
Okay.
even if the court were to act.
That was the mother. Oh, wait. Shoot, I didn't want to call anybody. What the world's going on around here? And that was my mom. I always have to put you on hold for the mother. So, all right. So let me get back here. My hubby says I talk a stops. right? My husband just shakes his head from now on. He's like, yeah, okay. But man, I could get him to agree to some major stuff. I'm like, hey, hubby. And I get the yakety yak, right? And I'm like, hey, how about new flooring? And I throw that in there, see? And he's like, yeah, well, that sounds great anyway. Then here come the flooring guys. He's like, what's going on? I'm like, yeah, you said. He's like, wait a minute. See, that's how you get stuff, okay? That's how you get stuff out of your husband. You yakety yak at him, and then you just kind of throw it in there, right? Oh my heavens. That's funny. But no, I do too. I like smaller chats because sometimes the chats get moving so fast and you can't really have a, one-on-one conversations, it seems like. But anyway, let's go ahead.
As ex parte in terms of, to have ex parte hearing in terms of the basis for the motion, I don't believe at this point defense will be able to disclose that information even to the court, even if an ex parte hearing were requested and or granted. It's defense's position that this information is necessary to be explored in terms of
Hindsight.
It's necessary to be explored in terms of the presentation of the evidence or presentation of the case because it's defense's position that at this time the information is confidential, which is why a witness list hasn't been disclosed. Discovery exhibits haven't been disclosed in regards to it because it's still being looked to and looked.
You couldn't give over some of this stuff, like some of the witness lists. I mean, I don't know what's going on here. I think she's trying to cause some problems. I don't know, though. I don't know.
And explored. As the state indicated, discovery is ongoing, and as discovery has continued to be ongoing, so has defense's preparation of the case, reviewing of the motions, filing of the motions, preparation of the motion, as well as in preparing this case otherwise for trial alongside the homicide case. So it's defense's position that the granting of the continuance in this case would not be an undue burden on the court. I understand the state having subpoenaed witnesses. The day that I found out about the information was the same day we actually happened to have depositions, so I spoke with the state in person about it, and then sent her an email in regards to her position, and then from there filed the motion to continue, and then we got hearing times while I was filed with Your Honor as another case, and I filed a notice of hearing as to that. Defense has been preparing, defense is preparing, and it's defense's position that denial of the motion to continue in this case would be an abuse of discretion, and we'd be asking the court to grant the requested continuance.
Thanks. Well, the court's in a difficult position evaluating the McKay factors. In this case, the court's going to find that there has been significant time to prepare for these hearings. This case initiated in February of 2024. Motion was filed almost a year later. The matter was set for a hearing in March. 13 months. I'll note that this is on 24 CF 632. While the two cases are related, this does not deal with the homicide case. The court has an inability to make a determination as to the likelihood of prejudice from the denial. The defense apparently is in possession of some information, the nature of that information, the timing of when it was received, whether the defendant played any role in shortening the preparation time. The availability of that discovery is unknown to the court because the defense is unwilling at this point to share any information with the court, even on an ex parte basis, as to this information. Counsel that has been appointed to this case has the requisite skill and experience to try this type of case. Both are either board certified criminal trial experts or in the process of becoming are being certified as a criminal trial expert. The court cannot, from the information presented, make a finding of good cause, and while the defense argues it will be prejudicial, there's been nothing advanced to the court to support that argument. So the defense's motion to continue the motion to suppress tomorrow, scheduled for 2 p.m., is denied. And I'll ask the state to please have their witnesses present and ready to go.
No problem.
Thank you. Matter set for 3 hours tomorrow at 2 p.m. That will conclude our hearing.
So do we see anywhere where it says the judge's name? No, I Googled it real quick, but I didn't see it. But damn, I think she means she's got sweet bugger. Let me tell you, I would say, hey, if I have to sit by you during this court proceeding, you're going to have to take a bath. You're going to have to do all of that because no, sir, So this is the tab I'm watching. It says in 6 minutes it should be starting. So we're just hanging out here for another 6 minutes and, go from there because we have got to watch it. This should be let's read what this chat's saying. There's only about 22 people in that chat over there. I'm not sure what other channels are sharing this, but we are definitely going to watch this go down. We're definitely going to be there on the 5th, the 6th, the 7th. I don't know if I'll be able to get into the courtroom. I think I seen Mama Llama say she was going to be there at like 2 a.m. Let me go back up in the chat because, my mom called and I had to take the call because I don't put my mom on hold. There'll be a day that I wish I could put my mom on hold. You know what I mean? So I don't put mom on hold. I plan on going. I'll be in line at 2 a.m. trying to get in too. If I can't get in, I'll wait outside and try again the next day. Right? I think that because I am in a couple of the groups on YouTube, or I'm sorry, on Facebook. I don't chat in there. I just read the information. And I'm hearing that people like certain TikTokers are going to be there and other people. So, and the community, people like, yeah, I'm going. And there's like 6,000 people in that group. So I'm like, wow. All right. So I don't know if we're going to be able to get in or not. But I don't know if I can go at 2 a.m. because I'm driving from my location, which is down by, I'm between Fort Lauderdale and West Palm Beach. So I don't know if I can. That's a long drive every day, right? And we were looking at hotel rooms and they're a little pricey. All right, to stay every day for a court trial. So I don't know if I'm going to be able to get up. That would make me having to get up at like midnight or sooner, like to go. So I'm not sure if that's going to be on my best interest to do that, you know. So, so I don't know if I'm going to be able to get up at 2 a.m. I know what I'll do. If my mom is there, I'm cutting in line with you. Okay, you just hold me a sign there that says someone's here. She's just invisible, but she'll be appearing in a couple hours. Hold the line for me, girl. I'm a coming. All right. So that's just that's a long haul to be there at 2 a.m. But I have no problem driving it, getting up at like 5, driving and being there, Man, I'm going to have to figure that out because if it starts every day at 9, I'm going to have to leave here pretty damn early. Pretty damn early and hope that, it's smooth sailing at those times of the hour, right? But that's okay. I'm good for that. I don't care. I want to go to this. It's my heart's desire to stand up for justice for Maddie Soto. And that's just the damn about what I'm going to do. Okay? Let's go over here and see if they started because it's 57. Now let's refresh to make sure we're not missing anything. Sometimes, you got to refresh the computer system. Make sure we're not missing nothing. We're not going to miss nothing. Okay? So I was on someone else's channel today. She's been around for a long time. And she was talking to her chat saying that for 24 hours, you cannot comment and chat. You just like take a time off, right? Just take time off of social media, not just YouTube, all social media platforms. So I'm going to try to do that. So I'm going to try to detox until we have to. And I said, well, I don't go into people's chat and be like, oh, I create content, because I really don't create content. I just talk shit. But so now I'm going to have to do this and then not watch anything else until after 1 o'clock tomorrow afternoon and see how it goes. No more YouTube, no more social media at all until tomorrow. She wanted to do a whole entire week. I'm like, well, I'm not sure if I can do that because I got to kind of keep up with the Stearns case. But maybe her little thing will let me at least do the Stearns case. And if I don't go and mess with anything else, maybe I can still be part of the experiment. I don't know. Okay, I might be booted out of the. Why do I get booted out of everywhere? Why am I always booted? I can't fit in anywhere. But it's hard to put, a circle and a square peg or a square peg and a round hole, right? Is that what they say? You can't put a square peg in a round hole. Well, I guess that's me. So I don't know why I can't fit in anywhere. My life, it's come to this, people. I don't know. But we'll do what we can. If we can't, what if I fail it? I'll be so disappointed. But what I'm going to do is, I used to ride my bike all the time. I used to ride my bicycle every single day, and I've gotten out of it. Okay, I've gotten out of riding my bicycle. So I'm going to jump on that sucker after I get done with this and feel that damn wind in my hair, honey, and be like, yes, ride that bicycle. I can't imagine you getting booted. I'm going to get booted. Bowberry, I'm getting booted, honey. People have sensitive feelings, right? I mean, I try to be respectful and be nice to everybody. And I don't really get offended too easily. I'm just like, just move on. Just move along. That's fine. But hopefully she doesn't boot me from the experiment. I would say her name, but I did not get permission, and I don't want anyone to, I don't want to, oh boy, she's been around for a long time. I used to go over there during the Ernie Shell days. That's how long I've been on YouTube. Not as a creator, just someone. Oh, here we go. Oh, I'm going to shut up now.
On the record, state of Florida, this is Stephan Michael Sterns, 2024.
Oh, Lord, that sound is terrible. Okay, we're going to have to put it on pause for a second. Okay, Mr. TV guy, you're going to have to get better audio than that. That's terrible.
TF-632. Right, the court has three motions before it.
Heavens to Jesus. What is going on? Why does that sound horrible?
Filed by the defense. The first in chronological order is a motion to suppress evidence obtained by unlawful seizure of a cell phone. The second is motion to suppress evidence.
Does it sound like that for you guys too? Let me go in here. As if it does, I'm going to find it somewhere else. Wow. Okay, I'll
obtained from unlawful searches of a cell phone. And the third motion, motion to suppress evidence obtained from Google search warrant. Some of the arguments are interlaced amongst themselves. The state of Florida has filed responses to each of the motions. In advance of this hearing, the court was provided with three audio recordings of interviews. The first recording of an audio interview was with Mr. Sterns and Detective Hunt. That was on February 27th at 12:00.
share this tab instead.
Costa. Third recording the court reviewed was identified as 24-1313_Stephan number 2. And that was an interview that occurred.
I think this might be
February
better.
28th at 12:16 a.m. I've reviewed those recordings in their entirety. I have reviewed the defense's motions. Some of the
audio's
interrelated
terrible.
arguments are that the seizure of Mr. Sterns' cell phone by law enforcement was
Hey, Grub and Sherry, it's good to see you.
initially pursuant to consent, but if that consent is deemed valid, that the scope of the consent was exceeded by law enforcement, that consent and subsequent consent were not a knowing, voluntary, or intelligent waiver
Yeah, she does look more professional.
of his Fourth Amendment rights. That's either that was by way of coercion or acquiescence to police authority or impairment by lack of sleep or ingestion of a sleep aid, and that no exigent circumstances existed to vitiate the need to secure a warrant prior to the seizure.
Second motion deals with a request to exclude evidence pursuant to the exclusionary rule, pursuant to an unlawful search of that cell phone. Again, the defense argues that any consent scope was exceeded by law enforcement, that alleged consent was not a knowing, voluntary, or intelligent waiver of Mr. Sterns' Fourth Amendment rights against unlawful search and seizure, again, by way of coercion, acquiescence to police authority, impairment by lack of sleep or use of a sleep aid, and that no exigent circumstances existed for the unlawful search. Third interrelated motion is a fruit of the poisonous tree argument that the subsequent information obtained from a Google search warrant from the initial search and seizure of the phone was pursuant to a warrant. However, the taint was not diminished. The taint of illegal activity was not diminished by the subsequent warrant, that the warrant lacked probable cause, and that the application for the warrant itself were defective on their face. The state's response is also interrelated on these related motions, indicating that the initial interaction regarding the search and limited seizure of the phone regarding the Google search was consensual. That subsequent consent was knowing, voluntary, and intelligently given to law enforcement, that there was probable cause for the seizure of the cell phone, and that exigent circumstances indeed did exist. They further argue as to the
you can see a number of lawmakers go over to State Senator Corey Simon, console him, put their arms around him, pat him on the back. Before here, in just a moment, you're going to see Senate President Ben Albritton also call a recess and go over there and console him as well.
We'll stand in formal recess. Senate will be back in order. For those in the gallery, what you just witnessed was beautiful and the best the Florida Senate has to offer. Amen, sister. Amen. Senator Polsky, for an introduction.
Thank you very much, Mr. President. I'm very sad to say that we also have some students here from FSU.
including other potential witnesses. Ms. Smith, whenever you're ready. Mr. Sterns, maybe a question from council table. We're going to swear in Mr. Sterns.
Please raise your right hand. Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And can you please state and spell your last name for the record?
Stephan Sterns, S-T-E-R-N-S.
And Mr. Sterns, did you come into contact with law enforcement in January of 2024?
I did.
During your contact with law enforcement, did they seize or take an item from you?
Yes, they did.
What item was that?
That would be my cell phone.
Do you know what type of cell phone it was?
It was a Samsung Galaxy, I believe it was a 24.
And what was your understanding, if any, as to what they were going to do with it?
They were just going to check my Google Maps and check to see if I was logged into Google, and that was it. That was all I agreed to.
Were you shown, or did they have a warrant?
They did not.
No further questions, Judge.
Thank you. Any cross requested?
Yes, Your Honor.
Thank you. Ms. Pennell?
Can I have just a moment?
Yes.
All this is horrible. All this sound is absolutely
Mr.
horrible.
Stearns, you briefly discussed having a conversation or being interviewed by Detective Tagler and Detective Acosta on February 27th. Is that correct? of last year?
That's correct.
And pursuant to the questions you were just asked, you had indicated that you did not consent to the search of your cell phone.
I consented only to them looking at the Google Maps and checking to see if I was logged into Google in the first place.
Oh my God, this is
Did
horrible.
you
I can't
have the
understand.
opportunity to see what law enforcement was doing on your cell phone?
No, as Acosta was still talking to me, Tagler walked away and began searching all the things that I did not consent to.
Isn't it true that she actually handed your phone back to you?
Briefly, what she told me to input my PIN because it had locked itself.
Are you guys hearing it as bad as me? This is absolutely horrible right now. This is horrible. I can't understand a damn thing the guy's saying.
And Detective Tagler actually mentioned looking at your history, which you okayed, correct? Your Honor, can we approach?
Yeah, come on up.
Can someone please call the news station and let them know that all the feeds are bad? Okay, let me see if we can get a hold of a TikToker over there on Facebook and say, hey, can you let them know? Let me see if anyone else is streaming it. It's better. Give me a second, guys. I know some people that are streaming it that's on TikTok. We might have to listen to a different way.
Was in fact your cell phone.
Yes, it was.
I don't have any other questions.
Thank you. Any redirect? Thank you. Argument, state. Court's going to find that there has been record evidence to establish that Mr. Sterns was the person that was affected by an alleged violation of his Fourth Amendment rights, that the property alleged in that violation was admitted to be his, and I'm going to say that
This is ridiculous.
burden has indeed shifted to the state regarding the defense's motion to suppress evidence obtained from the unlawful seizure and search of the cell phone. State, do you anticipate presenting witnesses or evidence?
Yes, Your Honor.
Thank you. I'm going to call your first witness.
The state will call Detective Francis Hunt.
Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Of course. Attorneys on both sides are welcome to move about the well as they need to.
Good afternoon. Will you please say your first and last name and spell both of them for the record?
Francis, F-R-A-N-C-I-S,
better
Hunt,
now.
H-U-N-T.
How are you employed?
I'm a detective with the Orange County Sheriff's Office.
What was your assignment with the Orange County Sheriff's Office in February of 2024?
I was and am currently assigned to the Domestic Crime Squad.
How long have you been assigned to that particular squad?
About a year and a half.
How long have you been with the Orange County Sheriff's Office?
About 5 years.
Were you assigned to the investigation into Madeline Soto, who was reported missing?
Yes, ma'am.
Did you have the opportunity to come into contact with somebody identified as Stephan Sterns?
Yes, ma'am.
When did you have contact with Mr. Sterns?
The morning of February 26th, 2024.
February 26th, the Monday, or February 27th, the Tuesday?
I believe it was the Monday, it was actually the Tuesday morning, I'm sorry.
Tuesday. At the time that you had contact with Mr. Sterns, had the Orange County Sheriff's Office already been investigating the disappearance of 13-year-old Max Minnesota?
Yes, ma'am.
Did you have contact with Mr. Sterns and conduct an interview about 12 in the afternoon on February 27th of 2024?
Yes, ma'am.
And can you describe Mr. Sterns' demeanor during your encounter with him?
Nothing particularly notable. He seemed to have, I think he had just woken up about an hour before I made contact with him. He was an average demeanor, nothing particularly notable about it.
Was he cooperative with you?
Yes, ma'am.
Was he able to speak coherently to you and answer questions appropriately?
Yes, ma'am.
Did he seem to
parsed
have
him.
any difficulty understanding the conversation that you guys were having?
Not at all.
Was this interaction that you had with Mr. Sterns audio recorded?
It was.
Where were you at when you had this interaction with him?
I was at his home or at Jennifer Soto's home in Kissimmee. We were in my vehicle.
Was this located at 4012 Santa Maria Drive in
That's it.
Kissimmee? And was anybody else present during your conversation?
No, ma'am.
Your Honor, I would like to approach the witness with state's aid for identification. Did you have an opportunity to listen to the recording on state's aid for identification?
Yes, ma'am.
Is it a fair and accurate recording of the conversation that you had with Mr. Sterns on February 27th of 2024 at approximately noon?
Yes, ma'am.
Your Honor, at this time, the state will seek to introduce into evidence what's been marked state's A for identification and the evidence.
Yeah, we're not gonna be able to put up with this.
No.
They need to get the audio better.
Will be received as States 1 for purposes of this hearing.
During your interaction, you had indicated that you believe, well, actually here in court today, you indicated that you believed he woke up about an hour before you had contact with him.
I believe so.
What makes you say that?
I had first completed an interview with Jennifer Soto. I had gone back to my vehicle to make a phone call, and I think Stephan was upstairs in the home while I was interviewing Jennifer. When I had gone back in, he walked back down from upstairs and said that he had recently woken up within the hour.
And just no further. No further questions.
Cross-examination?
Good afternoon, Detective.
Good afternoon.
So just to be clear, when you're doing this interview, you're inside of the house, right?
I was in my vehicle.
Okay. When you first met with Mr. Sterns, you met him inside the house?
In the house, yes, sir.
Okay. And then you took him outside and put him in your vehicle, right?
Yes, sir.
And when you did that, that's when you learned about him being sleepy, it sounds like?
I don't think he was sleepy, but it sounded like he had woken up about an hour prior. Yes.
Okay. Woke up about 11 a.m.? It sounds like the interview was noonish, right?
Correct.
At any point, did you ever seek a warrant for any of the cell phones or anything in this case?
Oh, no, sir.
Okay. Did you ever look at a cell phone?
No.
Did you ever ask him about a cell phone?
No.
Brief moment.
Of course.
No further questions.
No, Your Honor.
Detective Hunt, step down.
Yes, Your Honor.
Is he excused from subpoena for today?
Yes, Your Honor.
Thank you, Detective. Nick, are you
Well, since I have a local station, what I'm gonna do is see if it's on TV, and I'll put my computer in front of my screen TV and see if we can get it that way, so. Because this is terrible. I can't hear.
do. Will you please say your first and last name and spell both of them for the record?
Myra Tagler, Maira, last name Tagler.
How are you employed?
The Orange County Sheriff's Office,
How long have you been with the sheriff's office?
9 years.
In February of 2024, what was your assignment?
I was assigned to the sex crimes unit.
Are you still assigned to that particular unit now?
Yes, ma'am.
How long have you been in that unit?
3 years and 2 months.
Were you working in your capacity as a detective in that unit on February 27th of 2024?
Yes.
Did you become involved in the investigation into the missing juvenile named Madeline Soto?
Yes.
How did you become involved?
I was tasked to assist the primary detective at the time, Detective Hunt, with canvassing.
About what time do you respond to assist in the investigation?
It was about 4 p.m.
And this was on February 27th.
Yes.
And where is the initial location where you responded to?
It was in Hunters Creek,
Did you respond to a residence in Hunters Creek or somewhere else?
somewhere else.
Did you respond to the command post?
Yes.
When you get to the command post, do you learn any information regarding the investigation?
Yes.
What information do you have after leaving the command post?
It's really low, but better than others.
I was
Okay.
advised of we have LPRs, which is tag readers, and I was advised of the direction of travel that Stephan's vehicle had traveled the day of the incident.
Were you
Crusty butt.
aware
Oh,
on the
crusty
date
butt.
and time that Madeline Soto had not gone to school on February 26th?
Yes.
Were you aware that she had not been seen since the morning of February 26th?
Yes.
And the information regarding the tag reader, did law enforcement identify the tag that was on a vehicle that the defendant had access to?
Yes.
And what was some information that you got regarding the location of the defendant's vehicle on the morning of February 26th, the Monday?
He had traveled southbound 3 times on South Jungin Parkway towards Kissimmee, which was away from the direction of Madeline School.
Are all of these times early morning and late morning?
Both.
And then did you also get some information that in the afternoon, the car was traveling in and out of St. Cloud, Florida?
Yes.
Specifically, the travel on southbound South John Young Parkway, were those times consistent with what the defendant had described to law enforcement as his location were?
They were not.
And were these, the initial time was around 8:15 in the morning?
I believe it was 8:10.
And then there was another one around 10 o'clock in the morning?
Yes.
And then almost around noontime?
Yes.
Thank you. Overruled as to leading, I've got a question. The times that you just gave were for identifications of the tag through the LPR system.
And then the afternoon times of going in and out of St. Cloud, do you recall what those were?
I do not.
That's just gross. I'm not bathing. Oh, crusty butt. Crusty butt Stearns.
Did you document those times and locations in your narrative that you drafted for the
Yes.
case? Would looking at your narrative assist in helping you remember the specific times that the vehicle was traveling in and out of St. Cloud?
Yes.
Your Honor, I'm approaching the witness for the record with Detective Tagler's 11-page narrative.
Thank you. I'm looking at page 4.
Does page 4 help refresh your memory as to the times that the vehicle was picked up on a tag reader going in and out of St. Cloud?
Yes.
They had to, Purple Haze. He's got the bugs.
Towards or into St. Cloud?
This is eastbound on US 192 and Pecan Street at 13:05 hours, and westbound on US 192 and Academy Drive at 14:23 hours.
Yes, it is. See, okay.
And you were equipped with this information at the time that you responded and met with Mr. Sterns in this case?
Yes.
Were you aware as to who the last person to have seen Madeline Soto alive or have seen her was?
Yes.
Who?
Stephan Sterns?
Was that consistent throughout a lot of law enforcement interviews that were conducted?
Yes.
After you get this information and your task is to assist in the investigation, what's the next thing that you do?
Detective Acosta and I respond to Kissimmee to their residence, and we meet with Detective Hunt.
When you say their residence, are you referring to Ms. Jennifer Soto and Madeline Soto's residence?
Yes.
That would be on the Santa Maria Drive.
Yes.
When you get to the address, who is there?
Detective Hunt is there. There's other patrol deputies on scene, and Jennifer and Stephan.
Is there law enforcement conversing with either Jennifer Soto or Stephan Sterns?
Not at the time.
Who is the first person that you speak with?
Detective Hunt.
Does Detective Hunt relay information that he obtained during an interview with the defendant to you?
Yes.
What information do you recall receiving prior to your interaction with the defendant?
He stated that he had spoken to Stephan and Jennifer, and to his knowledge, Madeline had not made it to school, that Stephan had dropped her off near the school, and that they were supposed to go to McDonald's, but they didn't. And then he watched her walk towards the direction of the school, and then he went home.
Did you receive at that time any information about the sleeping arrangements on February 25th of 2024, the night before?
Yes, Detective Hunt told me that Madeline and Stephan had slept together in room number 4 because Jennifer needed to get more rest that morning.
Equipped with this information, did you come into contact with Stephan Sterns?
Yes.
How did you know who was Stephan Sterns?
Glad to have you, Heroes Chris Painting Corner.
And how to find him in the area?
Detective Hunt pointed him out.
Was your encounter with Mr. Sterns audio recorded?
Yes.
As a detective, what is your
Barry.
uniform,
Yes,
for lack of
demon.
a better word, when you are at work? What do you wear?
Professional attire, like I'm dressed right now.
You're not in a police uniform when you make contact with Mr. Sterns?
I am not.
How about Detective Louis Acosta?
Same, not in uniform.
Does anybody approach Mr. Sterns with you and Detective Acosta?
No.
Where is Mr. Sterns when you approach him?
We're all standing behind his vehicle.
When you say his vehicle,
It cracked me up.
The Lincoln?
so the defendant's vehicle.
Yes.
And at this point in time, is the defendant handcuffed?
He's not.
Is the defendant free to leave?
Yes.
How is his demeanor, his meaning the defendant's demeanor when you're interacting with him?
He was very emotionless, but otherwise able to answer every question that we had for him.
Did he, the defendant, seem groggy, confused, unable to communicate with you?
He did not.
Did the defendant respond appropriately to questions that you were asking?
He did.
Would you classify his behavior towards you as cooperative?
Yes.
Can you explain to the court, I know that you indicated that you're all standing in the back of Mr. Sterns' vehicle, but can you explain to the court where everybody is positioned?
Yes. I was standing on the left side of the trunk. Stephan Sterns was standing directly next to me. We were basically shoulder to shoulder. And Detective Acosta was standing closer to the wheel well on the right side and the corner of the car.
Was Mr. Sterns' path of travel impeded by either of you?
It was not.
Was Mr. Sterns free to leave?
Yes.
Did Mr. Sterns ever communicate with you either verbally or by body language or physically a desire to end the communication with you?
He did not.
At some point during your interaction with him,
Put it in the chat, heroes.
request for Mr. Sterns to take out his cell phone
Yes.
or to look at his cell phone.
Yes.
Can you remember where the cell phone was, where the defendant's cell phone was when you asked this question?
I do not. It was in his possession, but I don't recall where he grabbed the phone from.
Did the defendant consent to allowing you to look at his phone?
Yes.
And do you remember if Mr. Sterns' cell phone was passcoded, protected?
It was.
Who entered the passcode into the phone?
Stephan.
After Mr. Sterns entered the passcode in the phone and unlocked the phone, what did Mr. Sterns do with the phone?
He handed me the phone.
While you are holding the phone, where are you standing?
In the same position next to Stephan.
Do you hold the phone in a way to allow others to see what is on the phone?
Yes.
Where is Mr. Sterns at as you are looking at the phone?
Directly standing next to me.
And initially, the interaction and how the cell phone comes out, you bring up looking at maps in the phone.
Correct.
Are you familiar with the type of phone that the defendant had?
I am not.
Do you also inquire as to taking a picture of, quote unquote, your history, the defendant's history? Do you remember that?
Yes.
And that's also encompassed in the audio recorded interview.
Correct.
Does the defendant ever communicate to you any limitations on what it is that you're doing?
He does not.
Does the defendant ever attempt either verbally, physically, or in any type of way to cease the search of the phone?
He does not.
After you look at the maps, the history, what did you see? Or what did you notice in what you saw on the phone?
I noticed that he had mentioned that he uses Google Maps for basically everything to check locations, the time places open and close. And I noticed that on his Google history, it was very minimal. There was not a lot of traveling that was consistent to what he had originally said to both Detective Acosta and I. So then after that, I went to his call history, And I noticed that there was also not a lot of information on his call history.
And this was after you mentioned looking at his history.
Correct.
And during this entire time, did the defendant ever cease or withdraw his consent, either verbally or physically?
He does not.
After this initial interaction with the cell phone, do you keep the cell phone?
No.
What do you do with it?
I hand it back to Stephan.
Is it at this point that you walk away for a brief period of time?
Yes.
And do you come back?
I do.
Where Mr. Sterns and Detective Acosta are?
Yes.
Did anything about the circumstances surrounding this interaction with Mr. Sterns, either the location, the number of people, where people are standing, did any of that change?
No.
Was Mr. Sterns standing in a similar place as before you left?
Yes.
Was Mr. Sterns still free to leave and out of handcuffs?
Yes.
At approximately 7:57, do you again ask Mr. Sterns to unlock the phone?
Yes.
How does that happen? Explain that process.
He again enters the code and hands me the phone.
At some point, do you bring up the lack of call history to the defendant?
I do.
What was the defendant's explanation?
He said he had accidentally factory reset his phone.
After your interaction with him, you knew all of that information that you had previously explained that you knew. You had an opportunity to see things on the phone. And the information that you had that the phone was factory reset. What did you do?
At that point, I told him I was going to hold on to his phone.
And that was approximately at 8 p.m., 7:59, 8 p.m. on February 27th of 2024.
Correct.
After this interaction with him, did you secure anything else?
No.
Other than the cell phone, did you secure anything else or?
Well, I did ask him to refrain from going back in his vehicle.
His vehicle meaning the Lincoln.
Yes.
Was Mr. Sterns able to enter and exit Jennifer Soto's vehicle during the time between your two interviews with him?
Yes.
Was he free to walk about?
Yes.
Did you or Detective Acosta remain where Mr. Sterns and Ms. Soto were?
No.
What were you doing in between your two interviews?
After speaking with Stephan Sterns the first time, Detective Acosta and I went to the front of the apartment complex to speak with management and ask them to review their surveillance.
After doing these additional tasks, do you speak to Stephan Sterns a second time?
Yes.
This is approximately 12:15 in the morning on February 28th, right?
Yes.
Was Mr. Sterns handcuffed?
He was not.
Had his movements been restricted in any way by you during your conversation?
No.
Were you wearing the same clothes that you had worn a couple hours earlier?
I was.
Who was with you when you spoke with Mr. Sterns?
Detective Acosta.
At any point in time during either of your interactions with Mr. Sterns, did you or Detective Acosta remove a firearm from your persons? Did you guys take your guns out?
No.
Did you threaten arrest or anything like that during your interactions with Mr. Sterns?
No.
This second interview that you conducted, was that also audio recorded?
Yes.
Was Mr. Sterns free to leave at the end of the interview?
Yes.
In fact, he did leave your presence as well as Nation Bay, correct?
Correct.
Was Mr. Sterns' demeanor the same or different?
It was the same.
Did you have any issue communicating with Mr. Sterns?
I did not.
Was Mr. Sterns cooperative with you?
Yes.
And during this second interview, did you explain what law enforcement was seeking to do with Mr. Sterns' phone?
I did.
What did you tell him?
I asked him we wanted to, or I told him that we wanted to download the phone to see if we can get more information from his maps. And then he said that that was fine.
Okay. Are you sure that you specifically said that you wanted to download information, specifically the maps?
Not just the maps, just any information on his phone. I told him that we wanted to get more information from his cell phone.
Do you remember using the words, we want to download your phone, we want to go through your phone?
Yes.
During this encounter with him, you request specific consent from him to be able to go through the phone, right?
Yes.
Do you explain to him in your question what is going to happen or what your alternative route to obtaining that cell phone download is?
Yes.
What did you say?
When I explained to him what we wanted to do with the cell phone, I asked him if I had his consent to download the phone or if I had to obtain a search warrant.
And did the defendant consent to downloading the phone?
Yes.
Did the defendant provide you verbally with the passcode to his phone?
He did.
At the time that this interaction happened, did you or Detective Acosta impede or restrict Mr. Sterns' movements in any way?
We did not.
At any point in time, did Mr. Sterns seek to limit the scope of the cell phone download?
He did not.
Did you provide Mr. Sterns with your phone number or a way to get a hold of you after your interaction?
I did.
And did you give him any information as to when you would be accessible through that cell phone?
I did.
What did you tell him?
That my phone was on 24/7.
At any point in time, did Mr. Sterns reach out to you to either withdraw consent or limit the consent?
He did not.
Are you sure that he had a way to communicate with you?
Yes.
How do you know that?
Because Jennifer had her cell phone with her.
Are you sure that, do you know if Mr. Sterns and Ms. Soto left Venetian Bay together?
They did.
Do you know which vehicle they were in?
In Jennifer's vehicle.
I'm approaching the witness for the record with State's B for identification. Did you have an opportunity to listen to the recordings on State's B for identification?
I did.
Did they fairly and accurately depict the recordings of the two interviews that we discussed here in court with yourself, Detective Acosta, and the defendant in this case?
Yes.
Your Honor, at this time, the State received interviews and evidence worth the mark B for identification and evidence of State's
Be a composite exhibit with both recorders.
Yes, Your Honor.
Thank you.
No objection.
These and Bravo will be received as stated.
Can I have just a moment?
cross-examination.
Good afternoon, Detective. So your interactions with Stephan Sterns, they were audio recorded, right?
Correct.
Okay, they weren't video recorded?
No.
Okay. And let's paint that picture. When you arrived on scene, you said that it was you and another detective present, right?
Correct.
Actually, I think it would have been 3 detectives, right? You, Acosta, and Hunt?
Hunt was already on scene. Detective Acosta and I arrived later.
Okay, so 3 detectives now on scene.
Correct.
Okay. And alongside those detectives, you said that they were patrol deputies, right?
Yes.
From the Orange County Sheriff's Office?
I don't recall if it was us or Kissimmee.
Okay. Were they wearing uniform?
Yes.
Did they have their badges?
Yes.
Did they have their guns?
Yes.
Did you have your gun?
I did.
And did you have their badge?
I did.
Okay. And when you arrive on scene, you said that you first went to talk to Detective Hunt, right?
Yes.
Okay. And then afterwards, at one point you start talking to Stephan Sterns, right?
Yes.
Okay. And this is outside of his house?
Correct.
Because it's not allowed to go inside his house at this point, right?
Not at this point. The house was not secured.
Right. And when you're talking about secured, that's for securing for searching the house, right?
Correct.
Okay. So the deputies are making sure that he's not going back inside his house, right?
Nobody's doing that.
Okay. So at what point, let me ask it this way, how did he get outside of the house?
I don't know. I wasn't there when he was outside.
To your understanding, how did he get outside?
I'm not sure.
The law enforcement have told him to?
I wasn't there.
Okay. And when you're talking with him, at no point did you say, you can go back inside, right?
I did not.
At no point did you say, you're free to leave, you can drive away, right?
I did not.
Actually, and you kept him from going inside his own vehicle, right?
I did.
Because that was being secured for searching too, right?
At that time, I just asked him to refrain from going back in his vehicle.
Okay, so you didn't even tell him it was for search?
Not at that time. I wasn't sure what we had at the moment.
Okay. And then when you're talking with Mr. Sterns, you kind of give us a general overview that you said that he consented to searching his phone, right?
Yes.
Okay. Your specific question to him at first, going through the timeline, is do you mind if I look at your maps real quick, right?
Correct.
At no point did you say, do you mind if I dig through your entire phone at this point, right?
I did not.
Okay. And then when you get to the next question, it's do you mind if I take a picture of your history, right?
Yes.
Okay. Not take a picture of his lock screen?
No.
Not take a picture of his home screen?
No.
Not take a picture of his call history?
It was his history.
Not take a picture of his emails?
I did not.
Not take a picture of the entirety of his phone, just his history, right?
Correct.
Okay. And then when you get to the next thing, you say, is it okay, let me make sure this is right. Is it okay if I go in your settings real quick? I just want to see if you're logged onto your Google, right?
Yes.
And at that point, Mr. Sterns tells you that he is not logged into his Google, right?
Correct.
Okay. But then you keep pressing and then you say, is it okay if I check?
I asked. I didn't press.
You asked if it's okay you checked?
Yes.
Okay. And at that point, it was just to check whether he was logged into his Google, right?
Correct.
Not going through the entirety of his phone.
Correct.
You never asked him, can I go through the entirety of your
He
phone?
was standing next to me while I was on his phone.
Okay, so it's your basis that he has to say, no, you can just keep digging until he says stop?
Correct.
Really?
He was standing next to me and he saw what I was doing on his cell phone.
And did you ever ask him to go through the rest of your cell phone?
I did not.
Did you ever ask him to go into his call history?
I did not.
Did you ever ask him to go through his Google Drive on the phone, if it even was there?
I never looked at his Google Drive.
Okay. But you were looking at the rest of his phone, right?
I looked at his call history and his Google Maps.
Okay, because you were trying to figure out that timeline, right?
Correct.
It's the only thing you were looking for at this point, right?
Correct.
Okay. Did you ever go into the photos on his phone?
Yes.
While he was there?
Yeah, he was standing next to me.
Okay. Did you ever ask him if you could go through his photos?
I did not.
Right. And when you're going through those photos, I mean, let's talk about that. How many of his photos did you look at?
I think it was maybe 2 or 3 of the day Madeline went missing.
Just to be clear, you're not just looking at like the big grid, you start going into actual pictures?
I don't recall if I actually clicked on any of the pictures
Okay, so how do you know that you were just looking at 2 or 3 of those?
because it has dates on, like if you look at the grid, it shows dates for pictures.
Okay. And at any point, rephrase, at no point did you ask him to look at his photos?
I did not.
Then you go back to his Maps app at some point, right?
Correct.
And at that point, you're talking to him about the Snug Street address, right?
Yes,
Okay, and you never asked him if he could go back to the Maps app at that point, right?
I did not.
Okay. And just to be clear, nothing is visually recorded at this point.
Correct.
So when you say that you handed him his phone back, you never actually said, hey, here's your phone back, or anything of that.
I did. I said, here you go.
Here you go. Now, when you get the phone back from him, what do you say?
I said, can you please unlock your phone again?
Okay. And at that point, it's still you and Detective Acosta standing with him, right?
Correct.
Because you both are kind of tag teaming him, questioning him, right?
We're both talking to him.
Okay. Specifically, at what point did you say, here you go, when you handed him his phone?
Right before I stepped away.
Okay. You sure here you go are your exact words?
I don't know if it was my exact words, but I did hand him the phone and I said, here you go. It's in the audio recording.
And then at this point, you said you got him to unlock his phone again, right?
Yes.
And that's when you started digging through his call history, right?
I'm not sure what I looked at when I had the phone back.
Well, you specifically said, I also noticed I was checking your call history. I noticed you don't have anything before this morning, right?
Yes.
Okay. And at no point did you ask if you can go into his call history?
I did not.
You took the phone from him, what time was that?
About 8, a little after 8?
8 at night?
Yes.
Okay. Just to make sure we're paying that fair too. 8 o'clock at night you're speaking with him, right?
Correct.
It's about 50 to 60 degrees outside?
Correct.
Okay. And law enforcement's been standing around with Mr. Sterns outside?
He went to Jennifer's car after me and him spoke.
Okay, but before you and him spoke?
I can't answer that question. I wasn't there.
Okay, when you first showed up, where was he?
Outside.
Outside what?
I don't recall the exact location, but he was outside with Jennifer.
Right, so you know exactly where you walked, but not where he was?
Correct. I walked towards Detective Hunt.
Now, at this point, you collect Mr. Sterns' phone away from him for the final time that he has his hands on it, right?
Correct.
And when you take that phone away from him, you don't ask him for his phone, you take it from him, right?
I already had the phone.
Oh, right. And then you told him specifically that at this point, we're keeping your phone.
Correct.
Okay. Didn't give him a choice.
I said, I'm going to keep your phone. We want to download your phone.
Excuse me, what was the exact phrasing that you just said there?
That we wanted to download the cell phone.
You said that during the first interview.
The second interview, not the first one.
Talking about when you took the phone away from him, the first time, during the first interview. When did you tell him that you were going to download the phone?
The second time.
During the first interview, when did you tell him that you were going to download it?
The second time I spoke to him, not the first time.
You never said it the first time.
I did not.
Right. And then when you're talking with him that second time, you actually state to him, your exact words are,
Objection improper.
response? I'll rephrase. When you speak with him, did you tell him that we had previously said that we were going to download the phone?
Yes.
Your interactions with him were recorded.
Correct.
And when you originally took the phone from Stephan Sterns, Mr. Sterns was concerned about staying in touch with his father, right?
Correct.
Okay. And that's the point where you told him, well, you can just talk to him through Jen's phone, right?
Yes.
And at no point was he asked to consent to seizing his phone, right?
Correct.
At no point did you ever give him any form or anything to consent to seizing his phone?
I did not. Everything's audio recorded.
Okay. And at no point did you ever get a form from him consenting to downloading his phone?
I did not.
Okay. Because everything's audio recorded.
Correct.
Got it. And collect the phone at 8 at night. It's about 1:30 in the morning, you're talking to him again.
It's not, it's about midnight.
About midnight, okay. 4 hours then?
Just about.
Okay. You have the phone in your possession?
It was in my vehicle.
Okay. Ever apply for a search warrant at that point?
I did not.
Why not?
I didn't need, I didn't have like enough information yet as to what we were doing with the case.
Elaborate on that for me. What do you mean you didn't have enough information?
We knew that something didn't sound right, as like was speaking with him with like the timeline and things like that. But we weren't sure exactly what we were doing yet. I was waiting for my supervisor to contact me.
Okay. And when your supervisor contacted you, did he or she, excuse me? He. Did he tell you to get a warrant?
He did not.
Okay. Did he tell you to try and get that cell phone download?
He did.
Okay. And how did he tell you to get that cell phone download?
He didn't. He just said we wanted to get the phone downloaded, and that's when I asked Stephan if I had his permission to download the phone or if I needed to get a search warrant.
Right. You gave him the ultimatum at that point, right?
I asked him 2 questions.
Okay. So we can either get the phone or you can get a warrant, right?
Correct.
Now, at any point during these interactions, did you ever tell Mr. Sterns that he could have his phone back?
I told him his phone was going to be downloaded overnight and that he should probably get it in the morning.
Okay. And prior to the second interview, did you ever tell him he could have his phone back when you just took it from him?
I did not.
Okay. At any point, did you ever apply for a search warrant to download Mr. Sterns' phone?
I did not.
Did any other detective do that?
No.
Okay, because you're relying on that consent, right?
He gave us consent to search his phone.
It's a yes or no. Were you relying on the consent or did you get a warrant?
He gave me consent.
Now, when you're speaking with him, you became aware that Mr. Sterns had taken medication, right?
He said he had the night before.
Okay, and that was Ativan?
Yes.
And he told you why he took that medication, right?
Because he said he couldn't sleep and that he was very stressed and couldn't stop crying.
Right, and then he was also having panic attacks, right?
Yes.
Okay. And you knew that?
Yes, the night before.
Why your question? During the first interview?
Correct.
And the second?
Correct.
Got it. You aware what Ativan does?
I don't take Advance, so no.
Okay. You ever deal with anybody that?
Yes, Maricopa is also based in Florida, yes. Maricopa County, yes.
As to Mr. Sterns, he was wearing flip-flops at the time, right?
Correct.
Khaki shorts,
Yes.
thin hoodie.
Yes.
Told you he hadn't eaten all day, right?
Yes.
And was prevented from going inside of, sounds like his vehicle, right?
His vehicle, correct.
Okay. And again, couldn't go inside his own house, or not his house, but the apartment.
Not at the time.
Okay. And at what time, rephrase, at 2:40 in the morning on February 28th, you submitted his phone to the Orange County Sheriff's Digital Forensics Unit, right?
I did not.
You did not?
No.
Who did?
Detective Acosta.
Okay, so Detective Acosta was now in charge of the phone?
Yes.
Okay. You guys ride in the car together?
We did not.
You said the phone was stored in your car at some point, right?
When we were talking, or when we were looking at the video, yes, it was in my vehicle.
CLK.
When did you turn over?
Yeah, it's a well-known case in
At the end of the
States
night,
anyway.
after we secured the residence, which was around 1 in the morning, Detective Acosta was waiting for the tow truck for Stephan's Lincoln, and that's when I handed him the phone because he was going to Central Operations, and I was not.
Okay. Was that the last time that you had involvement with the phone?
Yes.
Okay. So after the handoff, nothing else, just to be clear?
In reference to, like, if I ever looked at the phone again?
Yeah.
Sure, I think it was like 2 days later.
Okay. So at that point, the phone's still in your law enforcement's possession?
Yes.
To confirm? Of course.
Redirect.
Defense mentioned that there were other law enforcement personnel that were at the apartment complex. During your interactions with Mr. Sterns, who was in the immediate area?
Just myself and Detective Acosta. Everybody was kind of just hanging out in the area.
Detective Tagler, I've got a question. When you initially interacted with Mr. Sterns, you indicated that you were going to take a photo of his history. Is that correct?
Yes.
Did you take a photo of his history?
Yes.
Was that on your agency cell phone?
Yes.
Any follow-up questions based on that question? State.
No, Your Honor.
Defense? Thank you. Will the detective step down?
Yes, Your Honor.
Detective Tagler excused?
Yes, Your Honor.
Detective Tagler
Thank
step
you.
down. Thank you. This is up.
Yes, Your Honor. Detective Lewis Acosta.
Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Will you please say your first and last name and spell both for the record?
Louis Acosta, Luisacosta.
How are you employed?
Orange County Sheriff's Office as a detective.
How long have you been with the sheriff's office?
5 years.
In February of 2024, what was your assignment?
I was a detective with the Orange County Sheriff's Office Sex Crimes Unit.
How long had you been in that unit at that time?
Approximately 6 months.
Are you still assigned to that unit?
Yes.
How did you become involved in the investigation of missing juvenile Madeline Soto?
I was the secondary on-call detective at the time, and I assisted Detective Tagler with the investigation, going over to the command post. We assisted our missing persons unit at that time.
What information did you learn at the command post?
We learned that Maddie Soto had been missing for a little over 24 hours. She was 13 years old. We knew that the last person who had seen her was Mr. Sterns.
Hey,
that basic
Shavy, good to
information.
see you.
Did you also get information regarding LPR tag reader hits on Mr. Sterns' Lincoln?
Yes,
And you also got the timing of those tag reader hits?
yes,
Did you respond along with Detective Tagler to 4012 Santa Maria Drive in Kissimmee?
yes.
And did you learn any additional information prior to speaking with Mr. Sterns at that address?
Yes, prior we were briefed of Detective Hunt, who's the initial primary detective assigned, just of additional details. For example, that she slept in the same bed as Mr. Sterns, things like that.
Did you assist in the interview of Mr. Sterns that was conducted by Detective Tagler at approximately 7:16 in the evening?
Yes.
And this would be on February 27th of 2024.
Yes, correct.
Where did this interview take place?
It took place in the parking lot of their, of the apartment complex near the residence, Maggie's residence.
Who was in the immediate vicinity as this interview was being conducted?
It was Mr. Stearns, myself, and Detective Tagler in the immediate vicinity.
Where would you say the next closest law enforcement official was?
At least 25 yards away.
Were all of the law enforcement officials within view of where you were?
The ones that were in the parking lot could see the general vicinity of where we were at.
How many law enforcement officials would you say were in the parking lot area where the interview was conducted?
Maybe 10, fewer than 10.
And were these law enforcement officers engaged in tasks, sitting in vehicle, like what was going on?
Yes, just kind of setting up a perimeter around the area, making sure media didn't get too close, just kind of standing by for tasks.
Scene security?
Scene security.
Did any of these other law enforcement officials have contact besides you, Detective Tagler, and Detective Hunt earlier in the day with Mr. Sterns while you were there?
While we were there? No.
Where were you and Detective Tagler and the defendant standing during this encounter?
We were behind the trunk of a vehicle. I can't recall the specific vehicle.
Was Mr. Sterns' ability to move about freely inhibited by either of you?
It was not.
How about any other law enforcement officer that was there?
No.
Were there any law enforcement vehicles prohibiting other vehicles from leaving the area or anything like that?
No.
What was Mr. Sterns' demeanor during your encounter with him?
Kind of very just matter of fact.
Would you classify his conversation with you as cooperative?
Yes.
What were you and Detective Tagler wearing? Not obviously specifics of what you were wearing, but were you in plain clothes?
We were, yes, plain clothes.
Did either of you ever remove your firearms from their holsters?
No.
Did either of you remove any handcuffs, taser, any type of weapon?
No.
Were there any threats of arrest made?
No.
Was Mr. Sterns free to leave?
Yes.
Did Mr. Sterns, based upon your encounter with him, seem to respond appropriately to questions asked?
In what way?
If you asked a question, did Mr. Sterns respond in a way that was coherent?
Yes.
Did you have any difficulty communicating with Mr. Sterns?
No.
Did Mr. Sterns fall asleep or ask to be excused from the interview?
No.
At some point, did Detective Tagler ask Mr. Sterns to look at his cell phone?
Yes.
Do you recall where the cell phone was during this initial interaction?
When she asked to view his phone, he said yes, and it was within eyesight of him. We were right next to him.
Who had the phone when Detective Tagler asked to look at some of the stuff on the phone?
Mr. Stearns had the phone, and then he gave the phone to Detective Tagler after she asked, and he said yes.
Did Mr. Sterns have to do anything to the phone prior to giving it to Detective Tagler?
He input his passcode to get it.
Where was the defendant and Detective Tagler standing while Detective Tagler was viewing the content of the cell phone?
They were standing shoulder to shoulder next to each other.
Were you asking questions at that point?
Yes.
Were you able to see the content of Mr. Sterns' phone?
At some point.
Were you standing next to where Detective Tagler and Mr. Sterns were standing or somewhere else?
Yes, next to both of them.
Was Mr. Sterns facing the general area of where his cell phone was being displayed from?
Yes.
There's a point in the interview where Detective Tagler steps away. Prior to stepping away, what is done with the cell phone?
She gives the cell phone back to Mr. Sterns.
Do you continue to have a conversation with Mr. Sterns?
Yes.
At any point in time, does Mr. Sterns discuss the content of the cell phone or Detective Tagler's looking through the phone?
No, I don't.
At some point, does Detective Tagler come back?
Yes.
And is the cell phone brought out again?
Yes.
At this point, who had the cell phone?
Still Mr. Sterns.
When Detective Tagler asks for Mr. Sterns to unlock the cell phone again, does he do so?
Yes.
Does he have to enter the passcode again?
Yes.
Are the circumstances surrounding this interaction the same as what you described previously as far as location and people involved, the defendant's ability to leave?
Yes.
At the time that that interview concludes, Detective Tagler keeps Mr. Sterns' cell phone, correct?
Yes.
What information did you have together about the Madeline Soto investigation?
So aside from what we had before, that she had been missing for over 24 hours, he was the last person to see her. There were many inconsistencies surrounding the time frame that he stated. He dropped her off and other things. And then the tag readers and information that we had about his movement.
Had the defendant been straightforward with you and Detective Tagler regarding his movements?
No.
I should be more clear. His movements the morning of February 26, 2024.
He told us certain movements that didn't correlate to the information that we had.
Did you confirm with the defendant that he regularly used his cell phone to get places, look up addresses, get store hours, directions, things like that?
Yes, I believe that was brought up.
Were you aware that there was very limited location data and mapping location data that was in his phone when Detective Tagler checked that?
Yes.
Were you aware also of information that was located in Madeline Soto's cell phone as far as communications between her and the defendant?
Yes.
What information did you have about that?
They communicated extensively, including very late at night.
Were you also present with Detective Tagler at the conclusion of this interview between the second interview that was conducted at 12:15 a.m.?
Yes.
What were you guys doing in that interim time?
So in the interim, we were reviewing surveillance video from the apartment complex to corroborate the times that he came back into the apartment complex.
Did you learn any new information when you did that?
Yes. One of the surveillance videos that we saw, it appeared that there was somebody either asleep, passed out, or not awake on the inside the vehicle.
What exactly did you have information as to the last clothing items that Madeline Soto was reported to wear?
Yes.
Was the individual in the driver's seat or passenger seat is what you just described?
Yes, wearing the same.
Were they in the driver's seat or passenger seat?
Passenger seat, front passenger seat.
What about their appearance makes you believe that they were not awake?
Slumped over, kind of leaning back. Just did not appear to be awake.
And you observed this video between the first and second interviews.
Correct.
And the individual that you just described, was that consistent with the characteristics that you were knowledgeable about Madeline Soto?
Yes.
The second interview, were you present at 12:16 a.m. when Detective Tagler again spoke with the defendant?
Yes.
And it was during this interaction where there was a brief conversation. Did you have a brief conversation with the defendant about what was seen in Madeline Soto's phone?
Yes.
Did the defendant attempt to explain that to you?
Yes.
What did he say?
He initially said she thought of him as a father figure. Then he immediately said she thinks of him as a father figure. Just said that it was a father figure-like relationship.
And you also were present when Detective Tagler then speaks about downloading the cell phone.
Yes.
Can you kind of elaborate on that encounter as far as
She explained that we'd be taking the phone, be getting it back whenever the phone download was complete.
did Mr. Sterns limit the download of the cell phone in any way?
No.
Did the defendant refuse to give consent to download the phone?
No.
Did the defendant willingly provide the passcode to his phone?
Yes.
And all of this is recorded, right?
Yes.
At what point do you recall learning that the phone was factory reset?
I believe during the first interview, while Detective Tagler was looking through the phone, she noticed that the call logs, he only had calls from that day, the date of the interview, so from February 27th. So she asked him about it, why he only had calls from that date. He said he had accidentally factory reset his phone the day prior, attempting to do like just some sort of update. There you go.
law enforcement officer, have you had the ability to seize or collect cell phones belonging to individuals during investigation?
Yes.
When a cell phone is taken, are you aware, or do you put the cell phone in airplane mode or secured in any way?
Yes, it's placed on airplane mode.
Why?
To prevent it from being remotely reset or anything being deleted remotely.
So you're aware of that possibility?
Yes.
No further questions.
Cross-examination.
Good afternoon, Detective.
Good afternoon.
So the interactions between you and Stephan Sterns, that was audio recorded, right?
Yes.
Not video recorded?
No.
Okay. And it's my understanding that you have an agency-issued cell phone, right?
Yes.
And that has the ability to document photos as well as videos?
Yes.
Okay. Did you do any of that documentation, the photos and videos, while you were speaking with Mr. Sterns?
I did not.
When you said you arrived on scene, you said there was about 10 other either deputies or officers on scene?
Roughly spread around the parking lot area.
Okay. And you said that they were securing a perimeter, right?
Correct.
Making sure that media wasn't coming in and out of the apartment complex, right?
Yes.
Okay. So that means that there were going to be officers at the main entrance area of the complex?
Yes.
Okay. And they would have been staying right there the entire time, making sure who's coming and going, right?
Yes.
Okay. And then at this point, it sounds like the apartment was getting secured to search it, right?
Yes.
Okay. So does that mean putting up crime scene tape and everything?
I can't recall about the time of the interviews. They had crime scene up.
Okay. Some point it got crime scene tape, though.
Yes.
Okay. And when you say that the officers, deputies, whatever, were in the parking lot, were they just clumped up in one group together or across the entirety of the parking lot?
So some of the detectives were kind of in one group, and then uniform patrol were kind of in the perimeter for scene security.
And while State asked you if you ever removed your firearm, I just want to clarify, you had your firearm on you, right?
Yes.
And you're in plain clothes at this point, right?
Yes.
So is your firearm just chilling right there on your holster? Or-
Yeah. On my hip, yeah.
Yeah. So it's visible?
Yes.
And you said that while you're questioning, well, you and Detective Tagger were questioning Mr. Sterns, you're both standing by a vehicle, right?
Yes.
I don't know whose it is, but it was a vehicle, right?
Yes.
Okay. And at this point, Tagger's questioning him, you're questioning him, he's in the middle of you two, right?
I can't recall where he was between both of us.
Okay. But you're all towards, it sounds like the back of the vehicle?
Yes.
Okay. And you had stated that while Tagger was taking a look at the phone, you're close enough to see the phone, right?
Yes.
Okay, so you can actually see what's happening on the screen?
Yes.
Okay. So it's not like when we're saying that you're standing around the vehicle, somebody's over by the front of the car over here and somebody's all the way at the trunk of the car over here, you're all grouped up together, right?
Correct.
Now, it was during that first interview that you learned that the phone was factory reset somehow, right?
Yes.
And when y'all were leaving the scene, it sounds like Tagler gave you the phone?
She gave it to Mr. Sterns.
Okay. At the entirety of both first interview, second interview, everything, when you're taking the phone to the sheriff's.
Oh, sorry. Yes. Yes. Yes.
Gotcha. So you had the phone at this point?
Yes.
Before you had come into possession of the phone to take it back to the sheriff's office, it sounds like it was in Tagler's car?
I'm not sure where it was.
But between the first interview and the second interview with Mr. Sterns, it sounds like there's about maybe a 4-hour gap, right?
Yes, somewhere around there.
Somewhere take a look at the video surveillance, right?
Yes.
Okay. It'll take 4 hours to go through all the video surveillance?
Not all just at the video surveillance. We were also debriefing kind of next steps, things like that, discussing the case.
So when you're saying debriefing, like, right, just you and Tagler, or are you talking other people?
Other people, the unit,
Okay, so where does that happen?
in the management area.
Okay. So at that point, while you're debriefing, roughly how many law enforcement personnel are there?
I don't recall the number.
Do you remember anybody that was there off the top of your head? Sure.
Detective Tagler, myself, direct supervisors, so maybe a corporal and a sergeant.
Okay, so at least 2 other people present?
Yes.
And it's at this point, so that's where you all were talking to supervisors, right?
Yes.
And at that point, it sounds like one of the supervisors was like, hey, we need to go get that stuff, right?
Yeah, I believe it came up during the conversation.
Okay. And then during that conversation, did anybody ever mention, hey, let's get a warrant to download that?
Not to my recollection.
Okay. After you take the phone to the sheriff's office, do you ever interact with the phone again?
No.
Okay, so you just hand it off to the forensics guys and you're done?
Yes.
And did you ever ask Mr. Sterns if he could download the entirety of his phone?
I did, that conversation was had with Ms. Detective Tagler.
And did you ever seek a warrant to download the phone?
I did not.
Did you ever attempt to draft a warrant of anything?
I did not.
For your phone, Mr. Cooper? Between the first interview and the second interview, you had never, neither you nor Tagler ever gave the phone back to Mr. Sterns, right?
Correct.
You held on to it the entire time?
Yes.
No further questions.
Did you conduct any interviews between the first and second interview with Mr. Sterns?
Yes.
Who else did you interview?
Jennifer Soto.
So that was also during that 4-hour period?
Yes.
No further questions.
Detective, between the first and second interview, around a 4 hour, at the conclusion of the first interview, did you observe anyone direct Mr. Sterns that he could not leave?
No.
And when you returned after 4 hours, Mr. Sterns was where?
He was in the same parking lot area.
Any follow-up questions, State?
No.
Follow-up questions, Defense?
During that time span between the 2 interviews, did anybody tell him that he could leave?
I don't recall that.
Thanks. May the detective step down?
Yes.
Is he excused from this? Thank you, Detective.
Thank you.
Additional witnesses are out.
Yes, Your Honor. Sergeant Darko Dominic?
Darko Stamenic, Darko Stamenic.
How are you employed?
I'm currently a sergeant at the Orange County Sheriff's Office Digital Forensics Squad
How long have you been a member of the forensics squad?
since June of 2023.
What type of training have you undergone to perform some of your duties in the forensic team?
So going back to college at the University of Central Florida, I minored in IT. After that, I went to Cellbrite School, where I became a Cellbrite certified operator as well as Cellbrite certified physical analyst. Those are two certifications that we have to use some of the tools that we use. And then I also went to the International Association of Computer Investigative Specialists, where I obtained my certified computer forensic examiner certification as well.
Did you download any phones as part of the investigation into the disappearance of Madeline Soto?
Yes, I did.
Did you first download a phone that belonged to Madeline Soto?
Yes.
When did you begin that cell phone download?
It was shortly after 2 p.m. on February 27th.
Do you recall about what time that download was completed and viewable?
I believe around 5 o'clock in the afternoon.
That's a couple hours.
A couple hours, right?
Okay. So, can you explain how an extraction is done with the equipment that you used in this particular case?
Yes, so we have a tool that we use to extract the data. So we connect the phone to a tool. The tool's able to extract the data, bypass any whatever passwords there are on the phone, if there are any. Extract the data from the phone. Then we take that data and we have another tool that parses that data, basically makes it readable by a human.
Is the time that it takes to extract the data from a phone variable upon the specific phone and maybe the data that's included in the phone?
Yes, absolutely.
Specifically with Madeline Soto's phone download, after it was completed, did you have the ability to share the data with other law enforcement officials that were working that same investigation?
Yes, I did.
How did you do that?
So we have a tool where we're able to upload that data that we extracted, and we're able to share it in the cloud to detectives, so detectives out in the field can view it.
Did you do that with Madeline Soto's cell phone the same day that
Yes.
you covered the data?
Yes, I did. I'm sorry.
Did you also complete the cell phone download for the defendant, Mr. Sterns' phone in this case?
Yes, I did.
Do you recall when you received Mr. Sterns' cell phone?
Yes, so shortly before 3 a.m. on February 28th.
Did you wait at Orange County Sheriff's Office Central Communications Building?
I did, yes.
So you waited for Detective Acosta to come from Kissimmee?
Correct.
What did you do upon receipt of the phone?
I began extracting the phone, and then I went home.
Sorry to interrupt. 2:28 at 3 a.m.
Yes.
So what specifically did you do with the phone to begin the extraction?
Connect it to a tool and follow the procedures on the tool to begin the extracting the data.
Was the cell phone itself secured in any way prior to your receipt of it to secure the data in the phone?
Yes, it was placed in airplane mode.
And after you plug the phone into the equipment that you utilized, you said you went home.
Correct.
Did the cell phone download process during your period of absence?
Yes.
Did you secure the room that this was being completed?
Yes.
And what time did you arrive back?
I believe it was about 8 a.m.
Did you check on the progress of the phone download when you arrived back?
Yes,
Was it completed?
it was.
Can you explain, for this particular phone, I believe it was a
Yes, so you have to go into the settings of the phone. I believe this, the next button says general settings, so you have to go into there. Once you go into there, you have to scroll to a button that says factory reset. Once you press the factory reset button, it asks you a couple of times if you're sure. It makes you type in your PIN code to the phone again to verify that it's you to reset the password, to reset the phone, I'm sorry.
So it's multiple steps to actually accomplish a factory reset.
It is, yes.
Is this possible to do if you're simply updating the operating system on that particular phone?
No, the button to update is in a completely different part of the settings.
When this specific phone is factory reset and the user goes back on to, again, utilize the phone, is there any information that is populated on the phone from prior uses?
Yes, so when you're resetting the phone, it asks you to log back into your Google account, and then information that you have backed up on Google will repopulate onto the phone.
If the phone is placed in airplane mode, does that prohibit the phone from resyncing with a Google account?
Yes, it does.
If items are subsequently deleted from a Google account and the phone is in airplane mode, do the items remain on the phone if they've been backed up?
They do.
If a phone is factory reset, is it still possible to obtain location data and other information from before the factory reset?
It is, yes.
How do you do that?
Different ways. So, for example, the pictures, if pictures are backed up, if the pictures are pulled again, the pictures may have location data associated with them. So things of that sort.
Thank you. Cross-examination.
Good afternoon.
So, you're in charge of doing the forensic downloads of the phone?
Correct.
Okay. And when you're doing those forensic downloads, you said that there's a tool that you plug the phone into to fully download the phone, right?
Correct.
So it's not just downloading the information that's immediately accessible to the user, it's downloading everything, right?
Correct.
When it's doing that download, does it do a bit-by-bit copy of the entirety of that drive?
No, it depends on the phone.
Okay. And with this particular phone, did it?
This particular phone, it did a full file system extraction, so it's not a bit-by-bit copy.
Gotcha. So when it does that, though, if the phone's factory reset, you can still pull that information off the phone, even though it's not immediately accessible to the user?
Like, I'm sorry, what information?
The information prior to the factory reset.
Oh, no, not necessarily, no.
Okay, not necessarily, but in this case, you were able to pull information prior to the factory reset, right?
Yes.
Okay.
Yes.
And when it comes to pulling that information, how long can that information stick around on the phone?
So in this case, the information had repopulated after the reset. So it was on the cloud and then it repopulated on the phone automatically after the reset.
Okay. Do you know at what time it repopulated?
It was, I believe, around 2 a.m. After the reset. I believe the reset was around midnight, and over the next couple of hours, the phone repopulated.
You're saying 2 a.m. the same day that you downloaded it, or before?
No, it would have been when the phone was reset, and I don't want to speculate the date.
Gotcha, no problem. And when it comes to a phone being factory reset, are you on any kind of timeline to make sure to recover data?
Not really, no.
Okay, so that's not a concern to law enforcement, right?
No.
Okay, so once it's factory reset, it's factory reset, doesn't matter.
Right.
We're going to have to work on them getting better microphones. Thank you. because we can't hear you.
When you did the download of this phone, anybody give you a warrant alongside the phone?
No.
Nobody.
Did right? Witness, step down.
Yes, sir.
Sergeant Stinnett, excuse me.
Your Honor.
We'll take a 5-minute recess.
This court is in a 5-minute recess.
I mean, this is a television company. I mean, us YouTubers could probably come up with something better than this. You know? Why have an open court to, media if we can't hear it? Yes, I'm complaining today. I'm complaining. While we wait, I think it's time for a Mustang Sally. I'm just saying. We got to Mustang Sally it for a second. Stand up, everybody. Get that blood flowing. We've been sitting for 2 hours and 12 minutes. Some of us, anyway. Come on. All right, we got to get our exercise in while we're here, okay? Sorry, guys, we had to Mustang Sally. And that wasn't for you, you old crusty Sterns. That was for us. All right? Because you, sir, boy, I don't know if I'll be any good in that courtroom. I might be kicked out of that sucker because I want to, like, spitballs in the back of his bald head. No, I promise I will be respectful of the court. I will dress accordingly. I will do all of the things. Oh, it's empty. Oh, I don't think people could come in. Now let's, turn it around so we can see how many pews we got, would you? Because we need to know how many people of the public can fit up in there. I need a seat. I want the front row. All right. I promise I'll behave, even though I don't want to behave, but I will. Three and fam back in there just in the bushes. She's probably got all the good snacks too. Probably got she's fam. She probably got all the good kid snacks. Probably got Skittles, Starburst. Yeah, I don't want to see. Right. Excuse me. Right. Thanks for the reminder, honey. Right. No, forget that. Never mind. I want to sit in the back. Oh, furthest away from bed bug, buddy. All right. 3 fam out there cheesing too. Look at just cheesing. I got all the good. I'm gonna go hang out. Dog treats too. Well, my dog will. Okay, I'm bringing my dog. Bringing Mocha. And got all the snacks. Probably got those Hi-C things you stick the straw in, for a drink. She's got all of it back there, just hoarding everything in the bushes. Damn shame. Stephan Sterns, we don't like you. I want to let you know. Let me whisper something in your ear. Why your ear's this close, sir. We don't like you. We think, allegedly, in our opinion, that you're a big pile of cow dung. All right? And we hope that you receive a lot of time for what you've done. in Hero's opinion. Oh my. I know, right? Oh my goodness. I promise I'll be good. Dear Heavenly Jesus, if I get up in there, I will be okay. I won't do anything bad. But I'd like to pull his ears off of his head, to be honest with you. But I won't. Oh, do we still have a hot mic? Yeah. Keep talking, Sterns. Let's listen to what you're saying.
Sometimes I can get on a roll.
Look at Stearns. I don't think he's laughing at one bit. I bet you he's over there about to shit his pants. He probably does shit his pants, in my opinion. He probably Mr. Old Shitty Pants. No offense to people that have bowel problems. I'm not saying that. Oh, Shitty Pants Stearns. And how it picks up things that's not even said, like spare fish. What the hell is that? Closed caption, you suck. We need better audio. We need all of it. We need all better stuff over here. All right. Let a YouTuber in there. They will have the best microphones, everything, so we can then stream off of them. The pins for men. Yeah, that's what he needs. Look at him. Look at him. You know, and I'm going to be pissed off if they. Here's the thing. I was discussing this with my husband. I'm like, so what is this about? Today I said, well, they're trying to throw out the phone evidence because they didn't get a warrant for his phone. But they did ask him to have his phone. It's on audio. And they're like, see, he goes, that's what pisses me off with the damn police. They need to cross every T and dot every I, especially in cases such as this one. Do not mess up. Because if it would be as simple as them not getting a warrant. Not getting a warrant. You know what I mean? He's like, you know, being cocky, thinking that they have, you know, you something. So I'm hoping, you know, I do believe in the justice system and everyone has a right to a fair trial. But this SOB right here, get off by a technicality because the Osceola, I think it was the Osceola or Kissimmee police didn't cross every T and dot every I because they were a little freaking cocky and they didn't fill out the proper paperwork or a form or what have you. What if, and here's what I'm going to say, what if the video imaging did not turn out correctly? We just watched a case where they wanted the footage from the body cams and they weren't available because it was failed. Every police officer in that room of, you know, crazy mom over there that killed her husband, none of the body cams worked. There was no evidence on that. What if the same thing would have happened here? You know? Now that shit right there done pissed me off. I would have been madder than hell. He needs to meet Grady. He does need to meet Grady Judd. Grady Judd and the boys would have a good time with the likes of this guy. And normally, you know, guys know how I feel. Someone isn't guilty until they're proven guilty in a court of law. Unfortunately, with this situation, there is so much proof that has been brought to the forefront that I'm stepping out here and saying guilty, in my opinion, from the evidence already shown. But if the evidence gets thrown out because of lack of proper policing, I'm going to be pissed off. Here it seems polices do their work. You know, it's a hit or miss over here. You know, there are good cops. I'm not a police basher. Don't get that wrong. I don't bash the police, but there are some police officers that just think that they can strong arm people, and they just simply can't. Okay, you can't. You too have to follow the system. And sometimes the justice system is just a system. There's no justice in it, you know. I've seen both ends of it, you know, to be honest with you. I'm sorry, but I have my doubts about the justice system. And a lot of people that I have in my life and been involved in my life, they feel the same exact way about the system. I like to hope and try to stay on the positive end that it's going to work. But we have been let down on several occasions. You know what I mean? Because of technicalities, not enough proof. But I see both ends of it. Well, we can get into a lot of stuff about the justice system, believe that. But a lot of times, the evidence doesn't prove without a reason of a doubt, But here, they should have went and got the damn warrant. They should have he should have signed some type of paper. Even if the little notebook they carry in their pocket with the pen, they want to, what's your name? And they write it on their little notebook, their little pad of paper. Your name and your date of birth. If they were said, we have your phone, Stephan Sterns, can you please sign it? You know what I'm saying? They should have done at least that, for the love of Jesus. Yeah, delays. And like the judge said, delaying the court proceedings is a delay in justice for this young girl. This girl was 13 years old. She better get some justice. Yeah, get out the damn Barney Fife notebook, buddy. Okay, we're back.
Your Honor, let's seek some clarification from the court as to
Your shit.
whether we're going through all three motions today or just the first two that we're going over, because the state's position is that the burden is substantially different for the challenge to the warrant.
Understood. Do you believe that you have presented the witnesses?
We're going to need you to speak up.
Two motions?
The first two motions are the seizure motion and the consensual search motion.
Oh. Right, speak in the damn mic. That's why they have them.
Motion to suppress evidence obtained from the Google search
I
warrant.
need my blood pressure pills. I'm getting frustrated over here.
Defense does not have the burden or has satisfied its burden. I'll entertain argument as to that. Sure.
I can't hear nothing. I'm getting a little aggravated, to be honest. Yeah, I need to go zen. I need to breathe in, breathe out. Hands, palms up. Breathe in, exhale. All right. It's a joke around here, heroes, to be honest. I'm like, Lord, the blood BP pills. Lord, not today.
Primary basis for the state's argument is on four corners of the warrant affidavit. So when it comes to the burden itself, it would be, we would be arguing that it's satisfied at least for the arguments we heard at this point, considering that we're challenging the actual document.
We can't hear shit.
So, did you anticipate?
Document itself understood, so.
Support that motion?
No.
I'm just going to present argument.
Yeah. Based on, right now we have the chain of how the warrant came about, and then getting to the cell phone download, and then there's the warrant.
Okay. So, you're going to make argument as to the sufficiency of the warrant itself and technical defects?
Yes.
And rely on the evidence that's been adduced in cross-examination to support the probable cause, or the lack of probable cause for the examination. Does that give the state any clarity?
No, Your Honor, Florida Rule of Criminal Procedure 3.190, subsection G3 specifically states if the court hears the motion on its merits, the defense shall present evidence supporting the
Saying.
motion. The state may offer rebuttal evidence that the defense's burden is to show.
Oh, I just screamed in my own ear. Son of a
their grounds
bitch.
for suppression is there. I don't believe that burden has been met for the state to be required to present rebuttal evidence. The affidavit is not before Your Honor.
All right, so as to sufficiency of the warrant, what evidence does the court have to make some determinations as to the sufficiency of the warrant? Talking about the technical defects that are alleged in the motion.
Yes, Your Honor. At this point, it's,
You better come up with something really good.
Search warrants are not part of the court file.
Absent some affirmative presentation of evidence regarding the argument, there is some kind of technical deficiency that makes the search warrant of the Google activity unlawful. It's going to be hard pressed to make a determination as to that. Let me ask the state. Are you requiring the defense to recall the witnesses that have just testified, or if they can find their argument to information that was elicited either in direct on cross, does that satisfy their burden, or shall we go through that entire exercise again? Sure.
Your Honor, the state is of the position that the defense's burden regarding challenging the search warrant has not been met. The state's not going to require the defense to recall the witnesses that have previously testified. However, there is no information before the court about the Google search warrant at this point. So the state's position is that they have not met their burden pursuant to the Florida Rules of Criminal Procedure to shift, to require the state to present rebuttal evidence at this point.
Additional testimony, the court's going to rely on the testimony that's been provided. There was a direct, there was a cross-examination and redirect. That information is in the record. The defense can make argument that that satisfies their burden or not. Is the state anticipating presenting additional evidence?
The state has an additional witness should the court find that the defense has met their burden to challenge the warrant.
Defense makes argument that Google warrant relied on illegally obtained evidence and that there was no attenuation of intervening circumstances that first obtained. There's her testimony from the investigating detectives that challenges the legality of both the search and seizure. That appears to be what the challenge on the warrant refers to, and that it is invalid as fruit of those illegal searches. As far as the application failing to establish probable cause, the court does not have the application. As far as the legal standard, probable cause in digital search warrants, the court is uncertain what kind of warrant this was or whether it was a digital search warrant. The argument that it fails to establish the sufficient nexus between the Google account and criminal activity, I don't have the affidavit, so that would be a difficult finding for the court to make. The reliance on boilerplate language, again, the court temporal scope of the court would have no evidence to support that argument, and peculiarity for digital searches. Without additional information, the court would find that there's no evidence to support that argument. As to the evidence supporting the arguments that the search warrant is invalid based on lack of probable cause, based on reliance on legally obtained evidence of intervening circumstances purging that taint, and being invalid as proof in illegal search and seizure. I think that evidence has been reduced in combination with the first two motions. So as to those issues, the court will find that there's been record evidence that supports that argument.
Given the hour at this point, defense will be asking if we can bifurcate first two motions from third.
These three motions were set together, and we're going to address all three.
Given the court's ruling, the state will call its next witness, Detective Taylor Heller.
Okay, so somebody in the chat, give me a recap because I can barely hear it on my laptop. I don't know if you guys can hear it any better, but I totally need a recap. What's going on?
Please raise your right hand and be sworn.
Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth, so help you God? Yes.
Right this way.
I can't either. This is terrible.
Please say your first and last name for the record.
Taylor Heller.
Can you spell both?
I'm
First name is Taylor. Last name is Heller.
How are you employed?
With the Orange County Sheriff's Office as a deputy.
Were you employed with the Orange County Sheriff's Office on February 28th of 2024?
Yes.
May I approach a witness with both the Mark State C for identification? Can you take a look at State C? Did you draft the affidavit for search warrant encompassed in State C in relation to the Madeline Soto investigation?
Yes.
Is this State C a fair and accurate copy of that affidavit?
Yes.
Your Honor, at this time, State C is introducing evidence with the Mark State C.
Thanks, heroes, for coming over and chilling out with us for the afternoon, and hope to see you back, and we'll come visit your channel as well. Enjoy the rest of your evening, afternoon, morning, depending on the part of the world you are. Peace.
Thank you.
I am so frustrated with this sound. Like, I don't even know if you can buy stuff to enhance audio. I have no idea. But this is frustrating me like you guys wouldn't even believe. I'm not kidding.
Take a 5-minute recess. Inside we'll have
Do not take an effing recess. We've been waiting. I just need to hear what you're going to do with the evidence.
The individual motions,
So they're going to go, I the recess part, right? Okay, I'm going to drop a link if anyone wants to come up here. Because I'm getting frustrated. Frustration sitting in. I do not understand what's going on with this audio. We can't hear crap. Yeah, right. Reverse image. I think you could be right. Their mics can now. I hear when the people are testifying, but nothing else. Where's he going for 5 minutes? He needs to sit there. You don't need a drink or nothing, bro. Just go back there and sit. Bed bug dummy. I don't know why I said that, but I said bed bug dummy. Oh my goodness. But I'm getting frustrated with this. The sound. This is ridiculous. Bed bug and bad decisions. Right? Absolutely. Bed bugs and bad decisions. Shoo, baby. You ain't never lied, honey. Okay? I don't understand this. I'm just trying to read the judge's lips, basically, to see is the evidence going to be in this case from the telephone, or is it going to be thrown out because the police officers didn't have him sign the freaking paper or get a warrant? I'm trying to read that. Yeah, me too, but I can't get, reversed. I'm trying to read the closed captions too, but sometimes it says like something really blah, 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 wonky. So I'm trying to, and I think it's so low it can barely pick it up. Even though the sound is horrible, thank you for doing. I know, baby, but I'm trying my hardest, honey. But because I know we're gonna hear, I think we'll get the gist of it. But you would think, and today we can send rockets to outer space, but we can't have good audio in a courtroom that's supposed to be televised for the public. I mean, Musk dude, Eon or Elon or whatever the hell your name is. I need you to go to this courtroom. I mean, you were in Florida a lot doing some spaceship shit. Can you go over this damn place and get us some audio? Because I'm about to have a stroke. All right. I'm about to have a stroke. Hell on earth, going to, I don't know his damn name, CLK. I don't, that dude that with the spaceships, he's, and with all the, internet. I'm waving my hands around in the air because I know, like, you guys can see me. I'm like, with the shit up there, If he can't get us some good audio and then, Lord Jesus, I would jump up, but I don't want my face all over. But you don't have to show your face reversed images. I would never do that to you. The people that come in here, that I are in here every day, and you hit the link, don't show your face. Turn your camera off. And matter of fact, here's what I'll do. Let me get a thing up here. We have those things I can put up that even if you make a mistake and have your camera on, so now you won't even be able to see yourself. Let me use this one. This one covers the whole thing. Yeah. Until we make sure you get your camera off. And then once we make sure you have your camera off, we'll take it down. I would never make you show your whole face to the world. I ain't that kind of girl. Honey, no, I have manners. I open car doors for people, and I invite you up here. I open the car door, close it for you. I'm very respectful. coming back in? No. I thought I heard jostling around. But I can see it from that one. Yeah, duh. I have a one screen I can see on. But don't feel like you're pressured to. I don't want you to ever feel pressure. Reverse images. If you're not comfortable, honey. But you about did it though, girl. You about took the plunge, reverse images. She's like, I'm going to do it. I know what you're like. I'm going to do it. No, I'm not. Yes, I am. No, I'm. Oh, she did. Oh, let's see. Okay. I was like, oh, no, she did. Here they come. We can sit up here. Let me take this off. No camera on, right? Okay. You have to unmute your mic, darling. We'll put this over here so we can still see our closed caption. Oh, there she is. Okay, her thing's off. Look at her. She did it. Now we're all.
Yay!
You did it, girl.
This time defense is moving to suppress
I did.
evidence obtained by way of the
I'm going to put this on mute so we can try to hear these doggone no microphone having ass.
Data that was elicited from Google that was sought by a warrant. Defense is also seeking to suppress the actual cell phone itself and the data contained therein. For the first two arguments as to the unlawful search and seizure of the cell phone, defendant is relying on the United States Constitution, Fourth Amendment, as well as the Florida Constitution, Article 1, Section 12, specifically that as we go through this is all kind of intermixed between the three motions, but looking to the first motion as to the seizure of the cell phone, at this point, now that the burden has shifted, the state bears the burden to prove an exception to the warrant requirement in order to seize the personal property of Stephan Sterns. As to the seizure, defense would argue that no consent was either sought nor given for the seizure of the cell phone, as well as the fact that there is no exigent circumstances that would create this to be a constitutional seizure. As to Detective Tagler, the exact evidence that was elicited was that the detective had informed Mr. Sterns unilaterally that she was going to hold on to a cell phone. This was a declarative statement, not a request, and there was no opportunity
we can actually hear now. This is
the
awesome.
turning over of the cell phone at that point. Detective Tagler had the cell phone in hand, was clearly exercising dominion and control over the cell phone, and told the defendant straight up that it didn't matter that he wanted to get in touch with his parents or to continue getting in touch with his parents as the night went on, and simply dismissed Mr. Sterns' concerns and unilaterally seized the phone. The seizure of the phone itself occurred at approximately 8 o'clock at night. I believe it was 19:59 hours on February 27th. And as of the morning of February 28th, the phone was still in law enforcement's possession. As it was taken to digital forensics at the Orange County Sheriff's Office, the phone was still in law enforcement possession, which we start getting to a point where we're looking at several hours worth of seizure. The state, or the defense, in its motion to suppress based on the unlawful seizure of the cell phone, had cited to United States v. Place where the seizure of personal property in that case was found to be unreasonable for a time span when this personal property was held for 90 minutes. We're well beyond 90 minutes at this point, and there was no attempt to minimize the intrusion of the seizure of the cell phone. Looking to the state's response, I understand that the state is going to be arguing exigent circumstances, but there was critical testimony elicited from the digital forensics examination witness who stated that once a factory reset occurred, to law enforcement, There was no hope of getting anything after that. During the first interview before the cell phone was seized, law enforcement knew that the cell phone had been factory reset. They dug through his cell phone and they confirmed that it was factory reset. At that point, no exigent circumstance existed as to imminent destruction of evidence, because at this point, essentially, Your Honor, it was destroyed in law enforcement's eyes. The gentleman testified the fact that there's no time span or immediacy when it comes to learning that the evidence could have potentially been destroyed when it comes to a factory reset. Additionally, the timeline itself of law enforcement's involvement in this case entirely negates the urgency element for the imminent destruction of evidence. From the time that the missing report came in to the time of the seizure of the cell phone itself, it was approximately 20 hours had elapsed. There was no immediate action taken to collect the cell phone, and this lack of immediacy completely contradicts the claimed imminent threat by the state.
Charges asked with destruction of evidence.
When it comes to the seizure of the phone, there was no warrant ever sought. There's no warrant that was presented.
Okay, I see nothing. I hear nothing. Hmm.
This was, again, unilateral action, even though there's been an emergency judge ready to go on duty since the 80s in the Ninth Judicial Circuit, both for Orange and Osceola counties, for law enforcement to seek a warrant, and yet they chose not to. When it comes to any other potential claimed exceptions, such as the emergency aid exception, it was clear from the detectives that looking through the phone, the seizure of the phone, this was in order to further investigatory purposes. This was not a situation where they were seeking to render any emergency aid. The community caretaking exception to the warrant requirement absolutely doesn't come into play. The phone posed no danger. There was no community protection purpose. This was purely an investigative seizure. As to the attenuation for this warrant, or for the seizure, there is no attenuation from the moment that Detective Tagler took possession of that phone, handed it off to Detective Acosta, and then handed it off to the Osceola, or the Orange County Sheriff's Office, I apologize. There were no intervening circumstances, and this was one continuous chain of possession by law enforcement. So, essentially the seizure, Your Honor, there's no warrant that's been sought, there's no exigent circumstance that allows law enforcement to collect this beyond the mere claim that they could just unilaterally take it. So for the seizure itself, we would argue that that's possible.
State, would you like to reply on a motion by motion basis? That'd be helpful.
In the meantime, I know the defense cited some of the case law from their motion. I did have the opportunity to review most of the case law. There is one case that I had difficulty finding, so if the defense has a correct site or a copy of the case, I would appreciate it. I could not find Appellate versus State, the site that you cite. I could not locate. It's on page 7 of your seizure motion. As far as the defense's argument, the defense relies on place, and place is actually distinguishable
Your Honor, I did provide a court exhibit A. I also have a flash drive. I prepared all of the state's case law from the motion, and I put it on a USB organized by motion so that it's easier to be accessible rather than writing a bunch of paper copies. The state's relying on all the case law presented in the motion, and I made it a court exhibit so that it's in the record for appellate purposes. The first thing that we need to do, Your Honor, is decide whether or not, or what type of seizure this was. I would agree with defense that this was a warrantless seizure of the defendant's cell phone. A warrantless seizure of the defendant's cell phone is permissible when you have probable cause plus a warrant exception. In this case, the state's relying on exigent circumstances. The probable cause, there's numerous case law that defines probable cause. The court's well aware of the case law defining probable cause and what it is. Exigent circumstances, there's also a lot of case law regarding exigent circumstances. The specific cases that the state is relying on are U.S. v. Babcock, State v. Darter. The state has to show for exigent circumstances. The test that's used is an objective one. The factual inquiry is the totality of the circumstances. The exigent circumstance that the state is relying on in this particular case is the destruction of the evidence. Courts have found this exception particularly compelling when you're dealing with digital evidence, and that can be found in the Babcock case. We have detectives who are on scene with the defendant, and at the time that the defendant's cell phone is seized, which is approximately 8 p.m., they had the opportunity to view some of the items in his cell phone. They also knew that Madeline Soto did not report to school. Madeline Soto has been missing for over 24 hours. The defendant was the last individual to have seen Madeline Soto alive or seen her in person. The defendant attempted to destroy evidence already by factory resetting his phone. He did this on the same day as Madeline's disappearance. That's evidenced by the history that is in his phone that he consented to looking at. The sergeant from the forensics unit testified what it takes to go ahead and factory reset the phone, but he also indicated that when a phone logs into the Google account and the backup starts repopulating, which is what happened in this case, that content will stay on the phone as long as the phone is not syncing with the Google Cloud account. There's evidence and testimony that upon the seizure of the phone, law enforcement officers placed the phone in airplane mode to prevent that syncing. Should the defendant have accessed his Google account and removed multiple items from the Google account, it would not have removed it from that particular cell phone because that cell phone was in airplane mode and was no longer syncing with the Google account.
How did it sync? How did it repopulate? Stop syncing.
When the phone was factory reset and that information corresponding with that Google Cloud account was input upon the starting up of the phone, everything that was backed up on the Google account from that phone began populating on the phone. And that's the 2 a.m. population that Sergeant Stamanik mentioned that occurred the early morning hours of February 27th. So prior to these interviews, all of those photos and everything else began to populate on that phone that was in his backup. So when law enforcement saw that there were various items missing and the defendant had already tried to destroy the evidence, it was at that point that they seized the phone, placed it in airplane mode to prevent further destruction of evidence. There was also testimony that
even though the defendant factory reset the phone, there was still a possibility through different avenues to ascertain that cell phone's location information and different things. So at that point in time, there was a fear that was objectively reasonable to a reasonable law enforcement officer that would lead that officer to believe that the evidence might be destroyed before a warrant could be secured. That is the standard. Probable cause plus exigency. Everything
Okay, Rivers, can you hear the stream, hon?
I can hear.
Okay, I was like, I hope she's not back there because I'm like, I don't want you sitting back there and not here, and I was so worried. Okay,
I just can't see.
what'd you say?
I can hear.
Her mic keeps cutting out.
I said I just can't see.
Okay, I think there's something that you can do that you can see the stream too, but I don't go on the back end. Maybe can you see the chat, because CLK may be able to see or put it in there what you can do to see the actual stream. I know there's a way you can, but I can't remember how to walk you through it. Yes, CLK is going to let you know. Can you see the chat?
I can see anything.
Okay. Go to the we'll practice. Don't worry. If you can hear, then we're okay. But I don't want you to feel like you're left alone, because you're not. We'll practice this. Don't worry.
Okay.
Okay. You did it though. I'm so proud of you.
that was known to these law enforcement officers prior to this seizure supports the probable cause finding as well as the exigency finding. They also were aware that the defendant was inconsistent in his statements to law enforcement about where his whereabouts were on February 26th, the day that Madeline Soto went missing, because his initial statements were contradicted by the actual tag reader for his vehicle. His vehicle was seen traveling in the opposite direction of Madeline Soto's school when he indicated that he was driving towards the school and go to McDonald's and dropping her off. There were other inconsistencies that are within those statements that he made, specifically the ones that were provided to the court and are entered into exhibits in this particular hearing. There are multiple inconsistencies. All of these things lead to probable cause.
Well, there's only a handful of us in here, so we'll work on this. We'll do it. Oh. So reverse images, if you can see the comments, there's one in the back. There's a private chat. So if you can go to that one, you can see too, maybe. Then she can walk you through it. I'm pretty new at StreamYard in the back end. I don't jump on people's channels, so that's why I can't walk you through it.
And exigent circumstances for the seizure of that phone. Therefore, the seizure was permitted by the Fourth Amendment in this case, regardless of whether the defendant said, yeah, go ahead and take my phone. The law enforcement officers had the ability to do that. The defense also mentioned place. That case is distinguishable because in that initial detention, that 90-minute detention that they're talking about in there was based upon reasonable suspicion alone. That court then later says that once that dog sniff was done on the luggage and they developed probable cause, that's where they get the 90 minutes from the time that the luggage is detained until they secured probable cause. That's not the standard here because the state's relying on the probable cause plus the exigency
to support the seizure. So the place case is actually inapplicable to this case as far as the defense's attempt to have the reasoning support their argument.
Thank you. Brief rebuttal, and then let's move on.
Briefly, while the state argues that there's the two-prong analysis as to probable cause and the exigency, again, when it comes to the exigency, the direct testimony that was listed during the hearing is that to law enforcement, there is no exigency at the point that the phone is known to have been factory reset, that there is no imminent destruction of evidence because there's no further destruction of evidence. It's already been destroyed. So while we can speculate and guess as to what Tagler and Acosta, the detectives on scene, were thinking as to seizing the phone, what we know for a fact from the Orange County Sheriff's Office is that they know that once a phone's factory reset, it's gone. There's no more imminent destruction. So for the exigency element, I would argue that makes sense. Moving on to the second motion, if Your Honor's ready.
Johnson, I'm ready.
Sure. As to the motion to suppress the unlawful search of the cell phone, again, the burden is flipped to the state. They have the burden of proof to show some kind of exception to the warrant to search of the phone. There's no warrant ever obtained for the actual search of the phone, be it the searches done by Detective Tagler on scene, nor the actual cell phone forensic download. Now, as to the first request by Detective Tagler on scene as to the maps, the statements from Detective Tagler was, "Do you mind if I look at your maps real quick?" At that point, the defendant, Mr. Sterns, had indicated, "Yeah, that's fine." When we look to consent, scope of consent is an essential element when looking to the validity of law enforcement's actions. At this point, there was limited consent to look only to the maps application only, not consent to search the entire phone. As to the second request, as to when Detective Tagler asked, "Do you mind if I just take a picture of your history?" and Mr. Sterns replied, "Yeah, that's fine." Again, this was limited only to taking a photograph of what was already visible on screen, not consent to navigate through the rest of the phone, through additional screens, not consent to access other applications. To the third request from Detective Tagler, if I can go into your settings real quick. I just want to see if you're logged onto your Google. Again, at this point, after pressing Mr. Sterns agrees, but again, this is, limited consent as to merely looking at the settings screen to determine if he's logged into Google. At no point did any of the detectives or any member of law enforcement seek consent from Mr. Sterns to go through the rest of his cell phone, which then we can see Detective Tagler's overstepping the scope of consent when she later indicates, "I was checking your call history. I noticed that you don't have anything before this morning." But when questioned, and as evidenced in the recordings that Your Honor has, there was never any consent sought or given as to checking the search of the call history in this case. So that is completely outside the scope of the searching of the maps, the history photo, or the Google login check. Additionally, when we're looking to consent as to Detective Tagler's request to do an entire forensic download of the phone, this is where defense relies on the Ramirez factors. When looking to the Ramirez factors, the defense looks to Mr. Sterns' freedom to leave. While the state is going to argue that he was free to leave, and the detectives stated that he was free to leave, No statement was ever made to Mr. Sterns that he was able to leave the scene at any time. Instead, what happened is that...
Is that required, or is that a factor to be considered?
It's a factor to be considered. And when considering that factor, we're also looking to what a reasonable person would feel in that situation. So at this point, Mr. Sterns is being corralled by two detectives by a vehicle. He's not allowed to go back inside of his home. He's not allowed to go inside of his own car. When it comes to the apartment complex, there's law enforcement all around. There's law enforcement at the entrance regulating who's coming and going outside of the apartment complex. It's clear that law enforcement essentially has this scene locked down. And not only do they have the scene locked down, while the state asked whether anybody had drawn firearms or anything of that nature, it was clear from everybody that testified that firearms were readily apparent, visible on scene, which would lead to Mr. Sterns feeling that he was not free to leave. When we're looking to any potential course of police procedures, again, we have a situation where Detective Tagler systematically keeps pushing boundaries of searching Mr. Sterns' phone. First, it's just a check for, hey, can I check the application? Then I want to take a picture of the phone. Then we're going to keep pushing into the settings. And then the detectives push more and more to the point where they start checking other parts of his phone without asking him for his consent. So at this point, a reasonable person would believe that, well, law enforcement has my phone in their possession. Law enforcement's going to keep looking through the phone. And while the argument is that he stood there and never said no, it's not the onus. The onus is not on Mr. Sterns to say no. The onus is on law enforcement to ask if they can continue to go through this, because the scope of consent is limited. And while the detectives and the state want to argue that, well, he stood right there and never said no, Your Honor, some 200 years ago, our forefathers said no for him. That said that we have a situation where there's no warrant. Law enforcement has seized his phone. They're searching his phone. The Fourth Amendment says that you cannot do that. The no has already been said for. When we're looking to the ability to refuse consent, additionally, law enforcement never told him that he could refuse to allow them to look through his phone. As to the education and intelligence, when it comes to law enforcement's testimony, they knew that Mr. Sterns was currently in a state of, or this actually goes more towards physical and mental state, that Mr. Sterns was currently in a distraught, stressed out state. They were aware that he was taking medication to try and fall asleep, to take care of himself during these long hours during the course of this investigation. When we're looking to the actual physical state of Mr. Sterns, we know it's about 50 to 60 degrees outside. We know it's night. We know the sun has gone down. We know law enforcement's with him. We know that he's in flip-flops and khaki pants, and he's not allowed to go back inside his house nor his car. So physical discomfort may have affected his decision-making process. When we look to the standards here again, it's not what law enforcement believes that Mr. Sterns was. It's what would the typical reasonable person have understood what the situation was. And in this case, Your Honor, the defense would argue that as Detective Tagler consistently pushed the bounds, then held onto his phone, just unilaterally seizing it, dismissing his concerns about trying to contact his family, comes back hours later and gives him the Hobson's choice, that ultimatum of, you can either consent or we can get a warrant. At that point, Mr. Sterns' ability to consent has been tainted, it's been coerced, and for that reason we would argue that all of the searches of the phone violate the Fourth and Article 1 section. Thank you.
Bring it, state. Bring it.
Your Honor, the defense is not arguing that the defendant did not consent to law enforcement looking at his phone. Some of the things that I think are important to point out to the court is that the
The defendant in this case was free to leave. Both law enforcement officers that were interacting with him were in an open parking lot where he was free to move about. He was in and out of Miss Soto's vehicle. There was no testimony before, Your Honor, that there was any threats or prohibiting of his movements. The defense argued that Detective Tagler consistently pushed the boundaries. However, Detective Tagler did not push the boundaries of consent in this case. There were multiple things where she was verifying with the defendant his continued consent for her to examine different parts of the phone. The defendant was in possession of his cell phone, unlocked it, and provided it to Detective Tagler. The defendant did not try and retain control over the phone. The defendant did not try and take the phone back from Detective Tagler. The defendant did not try to himself show her various portions of the phone. There was no attempt by the defendant to limit the consent in any way. The scope of the consent is measured by objective reasonableness. What would a reasonable person have understood to be the object of the search during the exchange between that person and law enforcement? You have Detective Tagler, after speaking with the defendant and him being inconsistent about timings and locations, she asks him, do you mind if I look at your maps real quick? The defendant confirms. It's at this point he unlocks his phone and hands it to Detective Tagler. Detective Tagler does not walk away with the defendant's phone. They are standing shoulder to shoulder. The defendant can see everything that Detective Tagler's doing. Detective Tagler then says, do you mind if I just take a picture of your history? To which the defendant responds, that's fine. There is no attempt to limit the type of history that Detective Tagler is going to look into. There is, this conversation happens, the detective is looking at the defendant's phone. Subsequently, the detective looks at the defendant's call history. And there's actually a conversation with the defendant about how Detective Tagler doesn't know how to use the defendant's specific phone. She also asked to go in the settings, and in the audio recording, there is actually a substantial pause before she's finds where the settings are. She actually says, I don't know how to use this phone. Sorry, I didn't mean to interrupt, as he's having a conversation with Detective Acosta as well. There is no time during that encounter that the defendant attempts to withdraw his consent or limit his consent in any way. The defendant does receive the cell phone back from Detective Tagler. There is a portion in the interview where she does say, here you go, to which the defendant responds, thanks. It's a little bit further away from the microphone, so it's a little bit harder to hear, but that conversation does take place before she asks the defendant a second time to unlock the phone. So the defendant does regain possession of the phone. Then she asks to unlock the phone a second time after she steps away. The defendant does so. Again, does not limit the consent in any way. There's actually no conversation at that point about what is going to be looked at. And then she brings up the fact that his call history is not there.
It's this information that she had prior to giving the phone back, correct?
She says, I was checking your call history. I am unclear at what point she looked at it. I believe it's around this encounter. but it could have been before. My position, the state's position is it's during this time frame where she's asking.
The argument of the state was that she asked to take a picture of the history, looks at the call history.
She takes because it's what a reasonable person would understand the interaction is going to be. My position is that she uses general term history, and then she eventually goes into the call history.
Is that in the first time she's got possession?
That's in the first time that she has possession of the phone. Yes.
At what point in that sequence is the exigency argument, is the state's position that the detective becomes aware of an exigency of the destruction?
It's the second time he hands her the phone. Because she asks him to unlock the phone. They have a conversation. She brings up the call log. She said, I also noticed, I was checking your call history. I noticed that you didn't have anything before this morning. Is that unusual on your phone?
And that's when the discussion about the
Factory
reset occurs.
Yes.
It's the state's position that on that discussion, that provides the basis for the state's exigency circumstance.
Yes, coupled with everything else that law enforcement knew, yes.
The probable cause.
Yes, yes.
Sorry, I didn't mean to. Mr. Rex.
So it's at that point that there's a seizure, there's some other information that's ascertained by law enforcement, and then they do a second interview with Mr. Sterns. The second interview begins at 12:16 a.m. and almost immediately jumps into addressing consent to forensically download the phone. It's not very long after their initial introductions on the audio recording. She says, I told you I was going to hold on to the phone. We would like to download your phone. Is this something that I have your consent to do, or do I need to get a search warrant for your phone? The state's position is the way that that statement is phrased, it is clear to a reasonable person that the defendant had the opportunity to refuse to consent, because either the defendant can consent. If the defendant does not consent, law enforcement ultimately would seek a search warrant. The defense wants to call that an ultimatum. The state's position is that it is advising the defendant very clearly that he has the ability to object or not allow consent for the forensic download. There's no question that law enforcement was seeking a complete download and to go through the entirety of the phone by the way that that conversation is had. Because he ultimately answers that question affirmatively, and then she follows up, you're okay with us going through your phone? To which the defendant responds yes, and then he ultimately provides his passcode to the cell phone. Based upon all of the totality of the circumstances and all of the information that law enforcement had and the lack of coercion by law enforcement towards, in fact, the defendant was actually free to leave and did leave the apartment complex after this second interview. He wasn't allowed to leave in his vehicle because his vehicle was seized, but he and Jennifer Soto left in Jennifer Soto's vehicle. That goes to any coercive nature argued by the defense. The state also relies on the same factors as permitted by case law. Whether or not the defendant was free to leave, whether there was any coercive police procedure, the extent of the defendant's cooperation or his awareness of the right to refuse, whether the defendant could have refused, defendant's education and intelligence, and the defendant's...
I think as fast as I type, so let's, I was with you up to extent of cooperation.
Or his awareness of his right to refuse, whether the defendant could have refused consent, the defendant's education and intelligence, and the defendant's belief that no incriminating evidence would be found. all of these factors should be considered by the court in determining the defendant's voluntariness of consent. So the state has to show that the consent was voluntary by clear and convincing evidence, and the consent has to be freely and voluntarily given. That is the standard. There was some case law that distinguishes it from a formal waiver of Miranda and things like that, other constitutional rights. The standard for consent is whether it was freely and voluntarily. So these factors that we just discussed go to the voluntariness of consent. So for the consent that occurs on February 27th, so that first interview where they're actually looking through the phone, the state's position is that consent was valid. The defendant unlocked his phone twice and handed it to Detective Tagler twice. The defendant specifically consented to map data viewing and documenting his history, reviewing settings to see if he's logged into his Google account. The defendant was standing directly next to Detective Tagler as she was viewing the content. There was not the word history was used in the state's position in a general way. It wasn't a limiting way. And at no point did the defendant intend or verbally or physically or any other way communicate that he was limiting or withdrawing consent. He was free to leave during the conversation. He was not in handcuffs. There was no police coercive tactics. The state's position is the defendant was aware, based upon the questioning, that he had the right to refuse. He could have not unlocked his cell phone. He could have said no. There was a lot of testimony that he was free to leave and he could not have consented. They're not in a confined space. And the biggest one is the defendant thought he destroyed all of the evidence. The defendant factory reset his phone twice on the date of Madeline Soto's disappearance. And the reason why he consented is he believed that everything was gone. So the state's position is that the consensual searches that were conducted in this case were valid and permissible under the Fourth Amendment.
Thank you.
As to the state's argument that looking to Mr. Sterns' belief that he was free to leave, again, this isn't on law enforcement's observations. It's based on what a reasonable person would believe in that situation. Here, while we don't have
We'll be right back.
I'm just excited.
What is going on? Why did they just stop? What the hell?
What happened?
They just stopped it.
The case?
They just stopped it. What is going on around here? We have no, yes, Bluefish, this is his hearing to get rid of the evidence of his telephone. What in the heck? Oh my gosh, we got to go find what in the heck is going on. This is not what. What's Grizzly saying? She's behind. What? I'm gonna. Grizzly, don't strike me. Wait till Grizzly watches this. I'm gonna share Grizzly. She's gonna freak out.
I haven't been able to see it at all.
I think that there
Show her
is,
various
put this on pause. I think that there is, so when you go through StreamYard, um, see, whenever I took the link so I could see it, so I'm gonna go hit the link again. Let me go. Oh, I'll drop the link for myself. Put myself on mute so we can kind of walk you through it. Because hey, this is a learning. We are a learning channel over here. We're the pelvic thrusting learning channel over here. We do not care, girl. We will get it hooked up for you. All right. Because I don't. What the hell is going on with everything around here? Copied. Paste. Paste. Stupid computer.
Reverse. Do you see like where it says chat comments and then there's like an X up there? Absolutely. I have a black screen. I don't know what happened.
Stop. Yeah. I'm going to mute myself. So whenever you go onto StreamYard and you hit the link and it says let's set you up for studio, and then you push for start your cam or stop it and mute and unmute, and it says display name, what your name you want on there, and then it says enter studio. When you first jumped onto when you first grabbed the link, you have to push enter studio. So now I'm up here, so you should see see mine. I think I'm echoing now.
I see two of you. You see two of me? No. Lady K.
But I'm oh, okay, I ended it. Yeah, if you should be. I see my phone might be different than yours, because whenever I hit it, I have an option to like enter the studio, and then I see the screen and the chat, but mine could be different than yours. What do you see, CLK, whenever you go to the link?
I'm on my phone, and then what it will come up like enter the studio, and then there's like down at the bottom you got your mic, your cam, your chat, and more, and then leave. If okay. There's an X, like say if I hit more, okay, that takes you to the comment section, right? I can hit that X button up to the top on your right, and then that takes me to where I can watch.
Oh.
Now I'm on an iPhone, so everything's different. You know what I'm saying?
Yeah, I'm on an Android, so whenever I hit the link, I can see the chat and my little screen of like a little, like just a half a screen of the what I'm showing and of the chat. The rest is the chat. So I think each phone's different. Heck, I don't know. I've only been on one other panel in my whole entire life. So and usually I'm just up here. So it's very odd.
It might be because Lady K, you're the host, so you might be able to see more.
Yeah, that could be.
You're hosting us.
Yeah, so I might see something different than you guys see.
You're the hostess with the mostest.
I don't know if I got the mostest, because man.
I'm on a.
What'd you say? You reverse?
I'm on a Surface.
On a what? I didn't get what you said.
I don't know what a Microsoft Surface. Yeah.
Girl, you're high tech. I don't even know what that is.
It's what my son brought me and said this is the best.
On your phone or
Girl,
laptop?
you can't come over here with those high tech. You can't come over here with that damn high
Right.
tech language. You know we ain't over here with none of that.
Okay. Maybe we need to wait.
We need to watch a damn YouTube video.
Yeah. Go to YouTube University.
YouTube University, we need help. Mr. Musk, get your ass over here. We need audio in the
Hello.
courtroom. We need to get her.
We need
We
hell
need her
on
to
here.
be a. We need reverse images, not to see black on her screen. We need some help over here. Okay. We need to know what happened to the dog on TV. Okay, we need to know what. I'm beside myself over here, girls. This isn't right. Everybody is getting fined. Okay. I mean, they got it right at the end. We're gonna listen to Grizzly because I bet you she just about stroke out too. Because Grizzly, this is not my content. This is Grizzly's. Let me share that link here real quick because I don't want to get
Okay.
in
I'm
trouble.
gonna wait.
Well, we'll keep practicing, girls. This is a practice channel over here. We
Yeah.
practice pelvic thrusting. We
Yeah.
practice getting on StreamYard. We practice all of the shit we're practicing. So don't worry about it. We'll figure it out.
Yeah, I have no idea what I'm doing.
I'm gonna wait until my son gets home and
Tell him we need help.
Hell on.
All right, we're gonna play.
Okay, so I'm gonna come out.
Okay.
And I'm gonna come out, and then I'm gonna see if I'm hooking something up wrong. How's that?
Sounds like a plan.
All right. I love you guys, and I will see you later.
All right, honey. Thanks for giving it a go. You did great. We did great, girls.
All right. Bye, guys.
All right. Bye. All right, CLK. Thank you for your help. We're gonna listen to Grizzly, and she's probably gonna stroke out too. She's gonna have a complete stroke. Poor Grizzly. I'm with you, girlfriend.
Portions of the phone. There was no attempt by the defendant to limit the consent in any way.
Yeah, we heard all this. We'll need to watch Grizzly stroke out because I just about did.
Measured by objective reasonableness. What would a reasonable person have understood to be the object of the search during the exchange between that person and law enforcement? You have Detective Tagler, after speaking with the defendant and him being inconsistent about timings and locations, she asks him, do you mind if I look at your Macs real quick? The defendant confirms. It's at this point he unlocks his phone and hands it to Detective Tagler. Detective Tagler does not walk away with the defendant's phone. They are standing shoulder to shoulder. The defendant can see everything that Detective Tagler is doing. Detective Tagler then says, do you mind if I just take a picture of your history? To which the defendant responds, that's fine. There is no attempt to limit the type of history that Detective Tagler is going to look into. There is, this conversation happens, the detective is looking at the defendant's phone. Subsequently, the detective looks at the defendant's call history. And there's actually a conversation with the defendant about how Detective Tagler doesn't know how to use the defendant's specific phone. She also asked to go in the settings, and in the audio recording, there is actually a substantial pause before she's finds where the settings are. She actually says, I don't know how to use this phone. Sorry, I didn't mean to interrupt, as he's having a conversation with Detective Acosta as well. There is no time during that encounter that the defendant attempts to withdraw his consent or limit his consent in any way. The defendant does receive the cell phone back from Detective Tagler. There is a portion in the interview where she does say that question affirmatively, and then she follows the consent that occurs on February.
Oh yeah, okay.
the feed just stopped. So let me just quickly see what they're doing here. Nope.
Right? Let's see if she finds it. Yeah, the feed stopped, Grizzly. We're freaking out over here.
Let's see.
We're stroking.
Yeah, the same happens on all the court feeds. So we are at the mercy of the court feeds. So that defense attorney had about 2 minutes left to argue his point of why they think it should be, this evidence should be suppressed. The judge will have to make his ruling on it. Once we know what the ruling is, I'm going to be monitoring the court, the court sites. I'll be monitoring X as well and the news, and then I will have a look and I will pin a comment so that well, did the judge rule today or not? I don't know if the judge will rule today, right?
Yeah, I guess I don't know will he rule today. I don't know, but I'm going to keep an eye on it as well. I'm like, this is bullshit. Okay, if it was us YouTubers over there, the audio would be so good we'd be able to hear a mouse take a shit. All right, and we would make sure that we have all the internet we need to freaking stream this shit. You need to let YouTubers just run the show from here on out, okay? Because apparently the news that this is their profession. They get paid the big bucks. We're poor, live on a beach in a tent over here, and we're doing a better job than you. I'm tired of your shenanigans. We need to hear what's going on. You cut us off like, you're done. You're not going to hear nothing. Lord have mercy. We've been waiting for this. We want justice for Maddie. We want her voice to be heard. We want it to be heard across the land because what has taken place with her is just absolutely disgusting and it just ain't right. And, this is just, and I think that Stephan Sterns over here just smiling like a damn goose that stole an egg or something because all of the mishaps that's happening. Not a good way to start this. Not a good way to start this at all. But, oh my gosh. So I guess what I'll do is just keep an eye on and see what happens. Maybe the local news will have something on there and I'll post something on my community tab. When and if I find out if the evidence is going to be old Krusty Sterns, right? Old Krusty Sterns over there smiling like an old bed bug. Bed bug and bad decisions, right? All right, so I'll leave a community post, or if I get a news clip of something, I'll make a video of it or something like that. So, anyways, thanks for hanging out with me here today, guys. That was a trying stream. Holy macaroni. From the audio and then oh man, this was almost like a freaking job. Hell with that shit, right? But I wanted to say thank you guys for hanging out. I appreciate you much. Until next time, take care of yourself out there. Take care of each other. Peace.
Never slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative.